My son is
That that would be much
gonna.
worse.
The worst.
your real time going?
We're back on the record on docket 24712 SC, and everyone is present. When we left Friday, we were pending the people's motion regarding aiding and abetting in the criminal jury instructions, and I asked defense counsel if there was any case law. We gave him time to review because I was inclined to grant it based on my review of the case law and the brief written by Mr. Primo on behalf of the people. Mr. Austin.
Yes, Your Honor. Thank you. I had an opportunity to review the people's bench memorandum as well as the law that the people cite, primarily relying on their argument that aiding and abetting would be a proper instruction in this case, which is the Robinson case that they cited. I've had an opportunity to review that and to do some further research into the aiding and abetting law. I'm not really disputing what the law is as far as what the requirements are and so forth for the aiding and abetting instruction. I did find something else I think was additionally useful. Part of the requirements that I don't think was particularly cited in the people's bench memorandum, that the defendant would be responsible for the acts of another person if he knowingly and materially rendered aid or assistance in the acts, or the acts were done pursuant to an understanding between the persons, or they were done in furtherance of a common person. What I think I'm really arguing here is that I think the facts as they were presented in this trial, I think are really distinguishable from the main case that the people are relying on in Robinson, which I believe dealt with multiple people engaging in assaulting someone in their home, and then one of the other actors ended up, killing that person, and could the other person be responsible for that, even though there was no prior evidence presented that the other person particularly participated in the killing of that person, or there was some type of other agreement or understanding between the two that was going to happen. What's distinguishable here from this and most of the other cases where we see aiding and abetting, for example, there was a case, and I can't remember the name, where there was joint people engaging in an armed robbery where someone ended up getting murdered. The difference is that the actors in those cases were clearly acting in concert. They had some type of foreknowledge or prior agreement to do something. The way the evidence bore out in this trial is that at some point during this party, there was a big physical altercation that erupted with multiple people. A brawl broke out with multiple people participating in physically assaulting Mr. Washington, and then ultimately somebody shooting Mr. Washington. And I think it's clear, of course, the reason why the people were asking for the aiding and abetting instruction is because there was a prior inconsistent statement as to the identity of the shooter of Mr. Washington. That came directly from Mr. Washington on cross-examination. So the people want to be able to, I think, argue that even if Mr. Anderson, or if the jury believes Mr. Anderson was not the shooter, that he was somehow aiding and abetting the person who did. But however, I don't think there is enough evidence that was presented at that trial to suggest that even if Mr. Anderson was doing something to participate in the physical assault, that he was necessarily doing so with the intent to aid or render assistance to the person who ultimately ended up shooting Mr. Washington. For all we know, he could have just been joining in the fray for whatever reason. So I think the facts in this case, as they were presented at trial, are distinguishable from the law that the people have cited. So I don't think the aiding and abetting instruction would be appropriate, and I would be opposed.
I think that Mr. Carino already addressed, and I'll give you another opportunity, Mr. Carino, but in his brief, he talks about Robinson and the Court of Appeals found that there was no evidence establishing defendant was aware of or shared the principal's intent to kill the victim, and accordingly reversed the defendant's conviction. The Supreme Court reversed the Court of Appeals, reinstating the conviction.
Don't say that last sentence again.
The Supreme Court reversed the Court of Appeals, reinstating defendant's conviction, and that was based on a rationale in part that when the legislature abolished the distinction between principals and accessories, it intended for all offenders to be convicted for the intended offense, as well as the natural and probable cause of that offense. So I'm not convinced that what you found changes my mind. In fact, I think it solidifies the need to grant this. But I appreciate you making the record. Would you like to add anything else?
Your Honor, no, thank you for that opportunity. The court has actually exactly mirrored the argument that the people are going to make. And I think that the court understands exactly the holding of Robinson, which respectfully is directly in accordance or directly opposite to what counsel just argued here today. So Robinson does extend aiding and abetting liability for exactly the factual context that we have before this jury. The jury is free to not find that the defendant was an aider and abetter, or the jury is free to find that he was the principal, as the people will be primarily arguing in our closing. But I think the court has identified the issue in the law appropriately, and that would be our no further comment. Thank you.
Thank you. And is there anything else in this regard you need to make a record of?
Just very briefly, Your Honor, again, in Robinson, there was a clear premeditation or some type of agreement or intent to act jointly, at least as it related to the assault. So they went in there jointly planning to do that. And again, I don't think the evidence as it bore out in this case would present that this was something that occurred just kind of out of the blue on the spur of the moment without even such time to formulate any such intent. And even if they believe that Mr. Anderson was participating in or aiding and abetting in some way the physical assault of Mr. Washington, I would argue that that was not the natural and probable consequence of then someone else taking it upon themselves to shoot Mr. Washington after that apparent physical altercation was over. I mean, I anticipate the court's ruling to be the same, but I just wanted to make that argument.
You made your record, my ruling is the same. Next, we have an issue with juror 4 has a girlfriend, significant other, that is having surgery at 10 o'clock. She had a ride and someone to stay with her and all of that arranged. For whatever reason, that fell through and he wanted to take her. And I did not want him to be otherwise occupied on getting out of here, making a rush decision in regard to the verdict, just to get it over with so he could go to his girlfriend's side. He certainly could have dropped her off and come here, but a rush decision, I think, would have been inevitable and not in anyone's best interest. So I did release him. Juror 11 also has a problem. We need to bring her in. Her issue is that she's an educator and a former student was killed this weekend. I think we just need to make sure she's okay to testify. We'll bring any of that in this case. It was a former student And she indicated she was perfectly fine to deliberate, and so I would rather do that than wait a day or two until everybody resolves their issues, and that she's gotta go to a funeral, and he's gotta take care of his girlfriend, and we're losing other people because we're right near the holidays and everyone has plans, so it's my decision to do it this way. We can make our record, we'll voir dire juror 11, but we need to proceed with this, the conclusion of this trial today. And then for as many days as they want to deliberate. I don't want them to feel rushed by the holidays either. We're just abutting a number of different issues. On behalf of the people.
Your Honor, thank you. As it relates to juror number 4, we were kind of given different or conflicting information this morning. I've now listened to the court's rationale, and it's our position that not only did the juror have what sounds like a family emergency that they had to attend here to this morning, this was not just a doctor appointment, but it was a surgical appointment. Also, Your Honor, the fact that I think the court's point is well taken. Not only does he have to physically be there with her, there's a risk that this juror could not be mentally here with us if a loved one is undergoing surgery or in a serious physical circumstance. So for those reasons, we understand the court's rationale. We do not object to the striking of juror number 4 here this morning. We would like the opportunity to voir dire juror number 11. It sounds preliminarily from what the court has indicated that she will be good to go, be fair and impartial. But I think caution dictates that we at least bring her in independently, allow counsel to voir dire her if necessary, and then make a final decision.
I appreciate that, and we will proceed like that. On behalf of the defendant, any further comment?
Yes, Your Honor. Certainly, we would like to voir dire juror number 11. And again, I understand the court's rationale for acting the way it did is to the dismissal of juror number 4 without the ability to consult with or ask counsel. However, just to preserve the issue, I would notice that we were not involved in the decision making on that process. So just to preserve the issue, I would voice my opposition.
Of course, we will bring in juror 11, but prior to that, the jury instructions we met this morning, I think you all have reviewed them. You've made a couple of minor changes. Does anybody want to make a record of that, or do you want to deal with juror 11 and then have an opportunity to go over them, because Brian just handed them to you?
I think it would be our preference, Your Honor, or at least my preference, to go forward and take care of the issue with juror number 11, and then we can very briefly put those issues on, because the corrections were minor to the final instructions.
Mr. Austin?
I would agree with that, Your Honor.
All right, juror 11, please.
All rise.
Thank you, you may be seated. Good morning, juror 11.
Morning. I am terribly sorry for your loss.
Thank you.
I understand that you lost a student, but it's a
It
former
was
student.
not a student, it was a student's father.
Oh, a student's father.
Student's father, yes.
Okay.
Yes.
A former student?
He was in my classroom for 6 weeks at the start of the school year. So currently not a student in my classroom, but a student within the building who was in my classroom earlier in the school year.
Okay, and did he die of natural causes?
No, he was murdered.
Okay, and how well did you know him?
I did not know the father. The student that I had in class, I'm not as close with him as I would be with somebody maybe I have all year long, but did develop a relationship with the student in the 6 weeks that he was with me, and still see him in the hallway and talk with him frequently.
And knowing what you know about that case,
Yes.
and you're able to deliberate and still be fair and impartial, or are you going to bring any of that in this case?
I think I would still be able to be fair and impartial. With my career, I know I have to separate my emotions from what I do oftentimes, and that's a big part of what I need to do. So I feel that I could do that.
All right, on behalf of the people, you may further voir dire.
Your Honor, thank you. Based upon the jurors' statements here this morning, the people have no additional voir dire, and we defer to the defense.
Good morning.
Good morning.
Well, to join in what the court said, I'm terribly sorry for your loss. How did you become aware of this?
It was a message, an email was sent to us by our principal yesterday to share with us that the student had lost his father. The only information that she had at the time and that she shared with us is that he had been murdered on Saturday, and it was not in home, and that the student was safe. That was the only information I was given.
And do you know if that murder took place here in this county or somewhere else?
Well, it was the Clayton County Sheriff that spoke with my principal, and I don't know where it occurred or the nature of what happened. That's the only information I have at this point.
Okay. And so you were not provided any details as to the manner or how or why in which this murder occurred?
I was not.
And given all that, you believe that you would still be able to be fair and impartial to Mr. Anderson in this case?
Yes, I do.
And if for some reason during this case or during deliberation, if something happens that you feel that you can no longer be fair and impartial, would you be comfortable in letting the court know that?
Yes, I would.
Oh. Thank you, Ron.
Thank you. Thank you very much, ma'am. We're gonna ask that you go back in the jury room. We will be with you all shortly.
Okay. Thank you.
All rise.
Thank you. You may be seated. I do not see any reason to discharge juror 11 on behalf of the people.
The people have no objection to juror number 11 continuing as a juror in this case and deliberating this matter.
On behalf of the defendant.
I would agree based upon the statements of juror number 11.
Thank you. Other matters we need to address before the jury is brought in?
Thank you, Your Honor. Very briefly, by stipulation, 2 additional instructions or instruction portions were added here this morning. First, based upon the facts that have been elicited in this case, counsel agreed for the court to read instruction 4.4, flight, concealment, escape, or attempted escape. And again, we believe that the facts support the reading of that instruction, and that's by stipulation. Next, Your Honor, 4.5, prior inconsistent statement used to impeach witness. That had been omitted, so we asked that it was included. It has been included in the package. And then the second half of that instruction has been amended by stipulation for a special instruction as follows, Your Honor. The instruction itself refers to preliminary examination testimony. The impeachment in this case was not from preliminary exam testimony under oath, but the defense did play a prior recorded recollection of Miles Washington. Under the evidence rules, it's our position that that may be offered for both impeachment and substantive evidence. So by stipulation, we've amended the instruction to read as follows. You have also heard, should change that to heard, says you may also have heard, but you have also heard evidence of a prior recorded recollection from Miles Washington. You may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statements when determining the facts of this case. So that's a special instruction, Your Honor, that amends the instruction as written, but it is by stipulation.
Counsel?
I would agree with that, Your Honor, as it relates to both of the added instructions. And I would just note on the prior inconsistent statement 4.5, there seems to be a minor typographical error that's found on page 27 of the instructions, last paragraph, first sentence. It says you have also here evidence. It should say heard.
I can fix that. Brian will fix that in the final instructions to the jury. And then 4.4 was also added, flight. By stipulation, correct?
That's correct, Your Honor.
Okay. Any further record before entrance of the jurors?
Your Honor, the people just asked the opportunity for 2 things. If we could just step out just for about 2 minutes before the jury comes in.
Sure.
And then also I want to get the puck going because I have a PowerPoint. I want to just make sure that that's set, please.
And do you have all the evidence you need for closing?
I do, Your Honor, yes.
Let's go up the record. Although I didn't ask you, Mr. Austin, is there anything else?
No, Your Honor, thank you.
Did you?
I did hear you.
I was looking at these. I've never seen it in a square. I was
Looks
like,
like a highlight.
yeah, I was like, I never seen anything about like that.
So I found those when I went to. State, but there's a place there. And then
Ah,
they
okay.
had for- Most everything.
Are you ready?
Oh, yes, Your Honor, thank you.
Okay,
Sorry about that.
go back on the record. Jurors, please.
All rise.
Good morning, thank you, may be seated. On behalf of the people. Argument.
Thank you, Your Honor. Good morning. In opening statements, ladies and gentlemen, the people told you that as members of this jury, you would be taken on a journey into two likely unfamiliar worlds. The first world we told you was the world of this courtroom where you have now spent the last over a week of your life. And before we begin here substantively this morning, ladies and gentlemen, the people want to tell you that within this world, the world of this courtroom, we could not have asked for a more attentive and cooperative jury. And on behalf of the people of the state of Michigan, ladies and gentlemen, we want to thank you so much for your time and service. It is today, however, that your most difficult job as jurors begins. It is today that you must deliberate on the evidence and you must determine what the facts of this case are. You must then apply those facts to the law that Judge Aquilina reads you, and in that way decide this case. The second world that we told you that the evidence would bring you into, we described as a very frightening world indeed. A world, ladies and gentlemen, where a minor act of disrespect results in a joint beating where you are hit and kicked and stomped and put to the ground. A world of lethal street gun violence, where a young man can be gunned down and left on the parking lot on his face in front of maybe, what, 30 people? Not one of them who has the decency to render any aid to him or stay on scene or speak to police about the events of what happened. And as we look at the evidence in this case that was developed by police, understand the context of that second world that the evidence has taken you into when you analyze all of the evidence. And we told you, ladies and gentlemen, in opening statement that within this world, this case would come down to four things. It would come down to violent assault, escalation, identity, and lethal intention. So we want to start our argument here today with this topic of violent assault. And it's important as you deliberate, ladies and gentlemen, on the facts of this case that you understand one thing. This happened, right? This event actually happened. This is not something where we're trying to figure out what was done. Was there a fight that went on? Was there participants? Were there gunshots? Was somebody got shot on the street? No. This actually happened. It's not about what was done. And the important thing to understand is that Miles Washington is not on trial in this case. This 21-year-old man did virtually nothing wrong that night. He didn't get what he deserved for being disrespectful to somebody. He didn't get what he deserved for showing up at a party that he was only quasi-invited to. Miles Washington was a victim that night of a very brutal group physical assault and then of lethal gun violence. You heard testimony in this case about the beating that Miles Washington was subjected to. But that testimony given to you in the form of hesitant 20 to 21-year-old people who are testifying in a large courtroom in a room full of adults in front of one of the participants in that group violence, that testimony doesn't really do justice to what actually happened that night. And we observe and we hear about a group of young men who approach and then a fight starts and there's punching and kicking, but it really doesn't show what happened that night. And we're fortunate enough because of the work of this detective that she was able to get video footage. Even in the context of that world, she was able to get video footage that document what happened. And we know, ladies and gentlemen, that you're going to go back into the jury room and you're going to watch this video over and over and over again. But it's important as we start setting the tone for what happened that night, this violent assault that then escalated, that we understand and watch for a moment this fight. When I introduced this video just now, I mistakenly used the word fight. Let's not call this a fight, ladies and gentlemen. A fight is a one-on-one or two-on-two equal participant fight or altercation that is going on. The correct word for what we see here is a jumping or a beatdown or a violent assault. Why? Because you have multiple people who are jointly attacking, hitting, punching, kicking, and stomping Miles that evening. Go back and watch this, which we know you will do, ladies and gentlemen. And watch how many different men are actually jointly participating in hitting, kicking, beating, punching, and stomping Miles. Look at how long this attack goes on for, 1 minute and 45 seconds. And how long is 1 minute and 45 seconds? Well, you think about how long it is when people are repeatedly punching you in the head, kicking you, stomping you, and you are desperately trying to get away. When you look at this video, discuss amongst yourself, ladies and gentlemen. Look at how often Miles is in a defensive posture. Look at how he is trying to get to his feet so he can, quote, flee, as he described to you on the witness stand. Try and count, if you can, how many different blows of kicks, punches, hits, and stomps land on his body. Watch as people come up to him and kick him while he's on the ground and stomp on his head. This is no fight, ladies and gentlemen. This is a beatdown, a jumping, a violent assault that did happen on the night of July 7th of 2024. And for what? For what? Because Miles bumped into somebody in the party that night? Because he bumped into somebody and said, "What's good?" Because he was at a party that his brother had invited him to and was standing in the front of the house? This happened, ladies and gentlemen, over nothing. And this group of men unleashed a fury of violence on this young man over nothing. And that is a violent assault. But that's not the end of the incident. And if you watch this video, ladies and gentlemen, stop it at 1:44. Because what happens at 1:44, approximately what we have on the screen right there, you're going to see Miles stand up and you're going to see Miles start to back up. And he described for you how his hair was piled up that night. You can follow him on the video, and that's a critical portion of that violent interaction. Why? Because it's at this point in time that this assault escalates. It doesn't have to, right? I mean, however awful that assault was, however senseless it was, however brutal it was over, or it should have been over. They beat him up, they made their point. Now this kid is standing on his feet and he is backing up. And remember what he told you, he's fleeing, he's trying to get out of there. He's keeping their eyes on this group that has just assaulted him. There is no reason for this incident to continue. And this is a critical moment because what happens, we know in this case. We know that as he is backing up after that incident is and should be over, that at least 2 men begin to follow him. They don't have to. They want more. They are escalating this event. We know from eyewitness testimony in this case, from Anaya Williams, who we'll talk about, and from Martrell Jackson, who we'll talk about, and from Miles Washington, who we will talk about, that at least two men acting at all times jointly together begin to pursue. And we will talk about in this closing statement the identification of those 2 men. But what we know beyond a reasonable doubt is that they continued to follow Miles and they are continued to pursue him. And we know that at one point, one of those 2 men, as they get to the area of the sidewalk, escalates it even further, because at that point in time, this man now has something in his possession, and that is a handgun in his hand. I want to talk a little bit about what your intent is when you are beating somebody like this group was jointly beating Miles. You're certainly not trying to just scare Miles. And maybe if you are punching him or throwing him into the ground, you're trying to cause him an injury or some sort of aggravated injury. But when you have 5, 6 men who are stomping on someone's head, kicking them when they are on the ground, your intention at that point in time is you're trying to call them great bodily harm. All right, you want to hurt that person. So that's where it starts before it now escalates. But when you pull out a gun, ladies and gentlemen, you are now escalating it to a different level, because as we're going to talk about, a gun is what? A gun's not a baseball bat used for baseball. A gun is not a pipe used for fixing your residence, okay? A gun is a per se lethal or deadly weapon. So when that actor, and we're going to talk about that actor's identification, when that actor pulls out that gun, he is now escalating it to a different level. He is escalating it to a lethal level. That's what guns are for lethal action. And we know in this case that that actor now pulls that gun out of his hand, and the first thing he does to escalate it is he swings that dangerous weapon at Martrell Jackson. And Martrell described for you how that gun was swung at him, and he told you how he ducked, and he told you how he was hitting the head, causing him some injury. Is there corroborating evidence of that assault on Martrell Jackson, which will be the felonious assault count that you must consider? Well, Anaya Williams sat up there, and we're going to talk about her credibility. And she described the same thing, that the actor had a gun in his hand and he swung that gun to do what? To pistol whip another person, Martrell Jackson. And Miles Washington got up there and corroborated to you that he began to swing that pistol at Martrell Jackson. And when he did, that's when Miles tried to intercede in this escalating assault. And it is in that moment that this case now turns into something called lethal intention. As we discuss lethal intention, ladies and gentlemen, I want to remind you again that this happened. Okay, no one's trying to say, was somebody shot that? No, we know that Miles Washington was shot. We know he was shot at least 2 times. So this happened. What does it look like when someone shoots someone at a party? So just give me a moment. We're going to start this about the time, if I can, when Miles gets up. If not, I'll just let it play. That's a great point.
No, Cindy don't piss me off. No, you grabbed me. You grabbed me the wrong way. I know, and I appreciate that. No, but I don't want Let's go.
Ladies and gentlemen, as you watch that video, and again, I apologize for some of the technology not being able to start at the exact appropriate stop part. You may begin at 1:44, and that will be Miles getting up, and that will take you to the shooting about a minute later. But as you watch that video, ladies and gentlemen, you can definably see, can you not, that escalation. We have a beating that's going on where people are watching this brutality going on with some interest in taking cell phone videos and acting in a very young way and trying to get in the middle of it and break it up. But what happens when those shots ring out, ladies and gentlemen? Do you see people turn and run as fast as they can away from that location? Because that's another human being shot in that moment. And those people are what? They are terrified. And why are they terrified? Because this confrontation, which started out ugly, grew to be a confrontation where you're looking for assault with intent to do great bodily harm, and it in that moment became deadly. But there's more, ladies and gentlemen. I want to talk a little bit about what it means to fire that handgun that night. Well, we know, ladies and gentlemen, that the police came and processed the scene and they found evidence, and they found, even though we heard 4 shots very clearly on that video during the escalation of it, police were able to identify at least 2 9mm shell casings. And you heard testimony in this case that where a gun discharges casings like this, that means it is a semi-automatic handgun, and we know and saw those casings. They are from a 9mm semi-automatic handgun, which is a lethal weapon. And we know from the testimony of the detective in this case that 9mm handguns just don't go off on their own, do they? There are a number of steps that have to be done. First, you have to get your gun, you have to possess it, you have to put a clip in it, and then you have to rack it and make it fire ready. And then you have to raise it, and then you have to point it, and then you have to fire. 1, 2, 3, 4. Those are all of the steps, the sort of premeditated or deliberate steps that you have to do to fire a handgun. So in that moment, at 1:44, when Miles gets up and starts backing away, between that moment and the moment that he shot about a minute later, that shooter had to have all of those things ready. They had to possess a gun, it had to be loaded, it had to be racked, then it had to be swung at Martrell and then pointed and then fired, not 1, not 2, not 3, but 4 times directly at Miles Washington. And I do want to make an important point about what it means to shoot another human being, right? We're not talking about shooting a target, shooting up in the air, in the range. We're talking about shooting a human being. Miles Washington was not a series of photographs in the hospital that night. He was not a video clip of that person, very tragically, but laying on the pavement. He was a living, breathing human being at 21 years old. And in order to shoot that person, the shooter needed to take that dangerous, lethal weapon pointed at their body, shoot them, and at some point during that 4 times, hit their body, watch that person's body be hit, and then proceed to shoot them again, hitting their body, and watch them fall on the ground, and watch them crawl on their elbows to that place of safety where they landed. That's what it means to shoot another human being. So when people are cavalier about what happened or quiet, understanding, that's what it means to do this event, which happened. you heard testimony, very critical testimony in this case from Dr. Nicole Fracticelli, who talked to us about the injuries that Miles actually sustained. And we want to talk about those injuries because they're critical evidence for you to consider, both in looking at who the perpetrator was and what their intention was when they fired those shots. Dr. Fracticelli is a board certified orthopedic trauma surgeon, she's on the trauma team at Sparrow Hospital. And she told you, ladies and gentlemen, that Miles sustained at least 2 gunshot wounds. He had 3 sites where he was shot, but those were likely 2 gunshot wounds. She indicated that Miles was shot to the right, that one bullet hit him in his right thigh. It exited out the back of his right thigh. It went into his left thigh, and then it went out his left thigh. So one of the things that we can learn from that, ladies and gentlemen, is that the shooter had to be close enough to Miles so that the bullet had enough force to go through both of his legs when it hit him, and that corroborates many of the things that our witnesses said. Dr. Fracticelli also said that Miles sustained a gunshot wound to his left knee that entered in the right side of his left knee and then partially exited his left knee, leaving this fragment inside of his body. And Dr. Fracticelli told you, as an orthopedic surgeon, some of the very serious complications that can happen when a piece of bullet is left in the knee joint. One of the things she described to you is that there is a high risk of infection with regard to the synovial fluid that's in that joint. And as a result, it has to be removed. And if it's not removed, the consequences can be what? Deadly. You can die from this. Miles remained in the hospital after having orthopedic surgery for at least 3 days. When he was released, he had minimal weight bearing and he had a cast, and he had to at least see Dr. Fracticelli for follow-up multiple times. These are serious injuries in and of themselves, ladies and gentlemen, but Dr. Fracticelli went on and she talked to you about the lethal consequences that exist when you shoot somebody in the leg. The first one, and I don't know if it's lethal, but it sure is horrible, ladies and gentlemen, is that that bullet that hit his thigh, it just missed his scrotum. All right? Think about that. But the more important fact from the lethality consequence is that you have 2 very important arteries in your thighs. You have the aortic artery and you have the femoral artery and you have the inguinal artery. And those are right there. And that bullet just missed the femoral and inguinal arteries. And what did she tell you happens? If you get shot in those arteries, you're going to bleed to death in how long? She said you're going to bleed out in 10 minutes. And that's just about the time it took for Officer Pulver and his team to get to Miles. So this young man was inches away from dying on that pavement that night. So what we learned, ladies and gentlemen, from the serious injuries that Miles sustained with complication and what we learned from the possible risks is that shooting somebody in the legs is as lethal as shooting them anywhere else in their body. You're going to be read 2 instructions in this case, ladies and gentlemen, about intent. It will be your decision to decide what the shooter's intention was at the time he fired that bullet. And one of the instructions Judge Aquilina gives you is that the defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. And that will be read in the context of a dangerous weapon. The intent with which an assault is made can sometimes be determined by whether a dangerous weapon was used. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. When you analyze the shooter's intention, we ask you to observe all of the circumstances in this case that happened from 1 minute and 44 seconds on that video when Miles stands up to the point that he's shot. All the thing that shooter intended to do. Well, that shooter intended to possess a 9mm semi-automatic handgun. That shooter intended it to be loaded and racked and fire ready. That shooter had to pursue Miles from where he was at the end of our initial confrontation, all the way down the grass to the sidewalk. That shooter had to pull up that gun. That shooter had to look Miles and then pull the trigger close enough so that it could go through both of his legs, and then pull it again so that it could hit his knee, and then pull it again and again. There's more about intention because we ask you to consider the position of the shooter at the time he pointed that weapon at Miles. And you heard eyewitness testimony first from Martrell Jackson, who said that the shooter held that gun right out in front of him. And you recall, I walked right up to the bench and said, how far away was he? He said about from where he was sitting to where I was standing. And for the record, we said about 3 to 5 feet. So that shooter is directly in front of Miles, pointing that gun directly at Miles when he fires those 4 gunshots. And Miles Washington, the person who got hit by those bullets, said he was facing straight on to the shooter, that the shooter raised the gun, and he said, pointed it directly like this, and then fired those weapons, that weapon right at him 4 times. It's important to understand, ladies and gentlemen, and I told you in opening statement that this red car would be an important fact. Well, why? Well, because when police arrived on scene, they saw in the red car what looked like 2 bullet holes. And those are kind of in a different location than where Miles was shot on the street. So it kind of looked like the shooter might have shot him twice and then done this and pointed the other direction just for impact or fear. But what we know from Miles is that that damage to his glass was already there. So those aren't from bullets, ladies and gentlemen. So again, consistent with our eyewitness testimony, our shooter holding that 9mm semi-automatic handgun fired it 4 times at Miles, twice hitting him, but trying to hit him 2 more times. 2 more times. So if you had a baseball bat and you hit somebody 1, 2, or swung at them 3, 4, missed them the second time, your intent might to be, with a non-lethal weapon. It could be used lethally, but it's a non-lethal weapon. Your intent might to cause them great bodily harm. Or if you hit them with a pipe, 1, 2, 3, 4, your intent might be sure to hurt them, but not to kill them. But ladies and gentlemen, when you take a powerful semi-automatic 9mm handgun and you level it up at someone's body and you fire into their body and at their body 4 times, you have one intention, and that intention is to kill them. And do not bite on the fact that he got shot in the legs. Being a bad aim or not knowing how to handle your firearm is not a defense to assault with intent to murder. This was a lethal escalation with gunshots fired for the only purpose one fires gunshots, to kill someone. As we look at the first count that you must analyze, assault with intent to murder, again, we will get to identification in a moment. So let's talk about for now just a person is charged with the crime of assault with intent to murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that a person tried to physically injure another person. If you have a gun and you shoot somebody, that is proof beyond a reasonable doubt that you are trying to injure somebody. Second, that when this person committed the assault, he had the ability to cause an injury, or at least believed that he had the ability. Again, when I have a lethal, deadly weapon, armed, loaded, racked, pointed, and pulled, I certainly have 100% belief that I can cause somebody physical injury. And third, that when this person, that this person intended to kill the person he assaulted, Miles Washington, and the circumstances did not legally or excuse or reduce the crime. Ladies and gentlemen, it is our position beyond a reasonable doubt that when you take a lethal weapon like this and you repeatedly discharge it into and at another human being, your intention is to kill them beyond a reasonable doubt. So as we move now into the final phase of our case, ladies and gentlemen, identity. We understand that we know a lot about this case, and the final piece that you will have to consider is, of course, the identification of the shooter. Before I move on to that identification, I want to briefly touch on this concept of felony firearm. You will see in your charge information or the instructions that are read to you 2 counts of felony firearm. Felony firearms are charges that accompany the substantive charges because you're using a firearm. So in this particular instance, assault with intent to murder is one of the charges you must consider. And if that assault with intent to murder was done with a felony, with a firearm, then you must conclude, if you find the defendant guilty of assault with intent to murder using the firearm, that he is also guilty of felony firearm. But of course, now we move on to the issue in this case that has been kicked around so much, and that is that issue of identification or identity. Understanding identity, ladies and gentlemen, will involve for you as a jury to use an interplay of 2 different instructions, okay? Certainly you have to look at all the instructions, but 2 primary instructions on the issue of identification. One is what we call the credibility instruction, which you see on your screen in part. I'm going to show you the second half of it in a moment. And then you will also have to look at a second instruction called the identification instruction. All of you during the voir dire process discussed how you would follow Judge Aquilina's law as read to you, and that you would apply some of these credibility factors to your analysis of who was or was not telling you the truth. As we start this, I want to talk about the second page of the credibility instruction, and I want to talk first about section 4. And this indicates as follows: sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. So you may hear, we expect, arguments about inconsistencies of testimony. Well, inconsistencies of testimony do not mean you don't have to believe the evidence. The law takes that into consideration. Go back into your deliberations, and each one of you will have a different recollection of what witnesses said, what suit I was wearing when the witnesses said that, and how Mr. Austin was acting during that. You all may have inconsistencies, but fundamentally, you may be able to agree on what the content of that testimony was, and you can look at all of the other evidence to decide what is reasonable. So just because there may or may not be inconsistencies, the law says that's okay. And we would also submit to you, ladies and gentlemen, that people who are coming in, who are not from central casting, who have not been paid to come in and testify, okay, people are doing their best to recall a traumatic incident. All right, if they are sitting there with a scripted lockstep type of analysis, that may be less credible even than one where there are normal, regular inconsistencies. So just because there may be inconsistencies in testimony, the law takes that into account. As part of some of the factors that you have to look at, there is no fixed set of rules for judging whether you believe a witness, but it can help you to think about these type of questions. Was the witness able to hear or see clearly? How long was the witness watching or listening? Did the witness have a good memory? How did they act when they were testifying? Did they seem to be making an honest effort to tell the truth? Does the witness's age and maturity seem to affect their testimony? Were they evading questions or arguing with the lawyers? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? So hold that credibility instruction right with there. You're going to have a copy of it as you're talking about the testimony of witnesses. Have it right there and use that as your guidepost in evaluating the credibility of witness testimony. So as we jump into the eyewitnesses, the first question that you as a jury have to conclude in the jury room is, was this defendant, Martez Anderson, even at that party on the night of July 7th of 2024? Well, we understand in the context of the world that police arrived in, it was very difficult for police to get cooperation. The police were able to dig and they were able to identify eyewitnesses in this case. One of the witnesses that was produced for you in this case was witness Jordan Glover. And it's important to understand as we talk about Mr. Glover that these are not the people's witnesses, okay? They're not the witnesses for our side. They are the witnesses. We represent the people of the state of Michigan. Everybody in this room is the people of the state of Michigan. And it is our job to present to you witnesses that were identified so that you may evaluate their credibility and testimony. As we look at Mr. Glover's testimony, under the credibility instructions, there certainly were some problems with Mr. Glover's credibility on this witness stand, all right? Obviously, Mr. Glover did not want to be here. Looking at factor number C, how did the witness look and act while testifying? Did he seem to be making an honest effort to tell the truth? Did he seem to evade the questions or argue with the lawyers? Well, you saw the changes in Mr. Glover's demeanor when I had him on the witness stand as opposed to when the defense had him on the witness stand. He was arguing with me. He didn't want to give straight answers. His answers were inconceivable in many instances. Some of the greatest hits that you can talk about when you go into deliberate about Mr. Glover, were you inside or outside at the time of the shooting? I was both inside and outside at the time of the shooting. So this is obviously someone who is not trying to be forthcoming with information, especially when we compare it to what we know in the video evidence. One of the things that this witness attempted to evade in his initial questioning was the mere fact that he even knew the defendant, Martez Anderson. Did we see that? The question that was posed, do you know Martez Anderson? No, I do not know this person. But as that testimony continued, not only did we find out that the witness knew Martez Anderson, but he was able to identify Martez Anderson in open court, and he was able to tell us that Martez Anderson was at his party on July 7th of 2024. And not only was he able to identify that he was at the party, he was able to tell us that he was with Cedric, and that he was with James, and that he was invited by Cedric, and that he had given Cedric carte blanche to invite any of the guys that he wanted to. So initially, Mr. Glover was attempting to hide that he even knew the defendant, but as the testimony proceeded, we knew that not to be the case. As we look at the credibility instruction, you may conclude in paragraph 5 that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. So again, you have to discern what was and what not credible from Mr. Glover's testimony here under oath in open court. Some of the things that he said that were corroborated by the evidence that we believe to be credible and ask you to decide as credible were as follows. He did reside at 6255 Beachfield. He did have a party. It was close in time to his birthday. His cousin is Cedric Jackson, and Cedric Jackson was at the party that night. He told you that Miles Washington was at the party and that Miles was not on his invite list. That sounds to be credible. He described that a confrontation occurred near the front door of the house and that he directed Miles into the house to get away from that confrontation. That all seems to be credible. And that he took Miles to the back porch, and it is there that this confrontation started. All of that seems to be credible and in accordance with the evidence. Here is where Mr. Glover went off the rails, ladies and gentlemen. It's extremely important to note that he admitted to you on the witness stand that what he told the police that night was that 2 unknown groups came to his house and were involved in a confrontation. And he admitted that that wasn't true. And he admitted that he lied about that. In fact, he identified to you that one of the groups that had the confrontation with Miles was his cousin, Cedric Jackson, and this defendant, Martez Anderson, and a man named James. And what's important to understand is that he described this defendant as a taller, skinny black male, and he described James as a heavier set male. That was all developed through very vigorous examination of a witness who was trying to hide information from you. Why do people try and hide information? Why? Because they don't want you to know it. So what this witness hid from the police was the exact identity of the people involved in the confrontation, the exact identification of the people he knew were in this fight, and the exact identification of this defendant, Martez Anderson. Ultimately, what we can call from this very difficult testimony is this: on the night of July 7th, 2024, an eyewitness has placed this defendant, Martez Anderson, at the party at 6255 Beachfield. Police kept digging. And you heard in this case that Detective McGonigal was able to obtain a cell phone, and she sent that for a forensic cellular phone extraction. And you saw that extraction, People's 52B. And what we were able to corroborate that night is that at approximately 1:33 in the morning, a person by the name of Said texted the defendant, Martez Anderson, inviting him to a party, and that party was located at the area of 6255 Beachfield Drive, which is, again, corroborative evidence of Mr. Glover that this defendant did at least at 1:30 in the morning on July 7th, 2024, go to that party at 6255 Beachfield Drive. There are independent witnesses in this case who also put the defendant at the party, and not only put the defendant at the party, but place him as one of the initial perpetrators, the person who started the fight on the back porch, and who also placed this defendant as the individual who swung that black handgun at Martrell Jackson, and also identify this defendant as the person who fired those 4 shots at Miles Washington. And I want to start with sort of a progression of those witnesses. And as we look at those witnesses, we're also going to consider our next instruction, the identification instruction. And this is an important instruction. You have to look at identifications very carefully. And you have to look at them both in the context of the credibility instruction. You know, how are people looking and acting? Do they have a certain bias in how this comes out? You know, those things. And then also some of the factors of the identification instruction. So we urge you, have those 2 instructions out when you are looking at the eyewitness testimony now of Anaya Williams and Martrell Jackson and of Miles Washington. So let's start with Anaya Williams. And I'm going to take you right back to the credibility instruction. Anaya Williams was an interesting witness. It did not appear that Ms. Williams was really excited about being in this courtroom. It also did not appear that Ms. Williams appeared to have any particular interest in the outcome of this matter. She did not appear biased towards either side. She was in a relationship with Miles, but was no longer in a relationship with Miles. She identified that she knew somebody by the name of Cedric as a boyfriend of her sister, and that through Cedric, she knew and identified in court this defendant, Martez Anderson. As you're looking at her testimony, under factor B, did she seem to have a good memory? Well, in a very matter-of-fact way, ladies and gentlemen, she was able to walk you through the events of that night. She ran into Miles. She described that there was some sort of confrontation on the side of the house. That ended up as a confrontation in the front of the house where the boys were going back and forth. She then walked into the house with them and was on the back porch. She observed a group of men came, and then this fight started. She described that multiple people were beating on Miles. There was as many as 3 to 5 people who were beating on Miles. She described that they were hitting him, kicking him, and even described that she was stopping him. All right, all of that is corroborated by the evidence that we know in this case from the video and other witnesses. So she appeared to have a very good memory. She described that at some point, the incident stopped, that Miles was walking back to the car. We know that to be accurate from the video. She said she was walking with Miles. She described that at some point in time,
2 additional men continued to follow them in that escalation phase. And we know from the totality of the evidence that that happened. And she described that those 2 boys continued to, what she said, talk crap or talk smack, whatever her language was, which we know to be the case. And then she sat here in open court and very casually and very calmly and without very much prompting, okay, identified one of the men that was pursuing as this defendant, Martez Anderson. All right? She wasn't jumping up and down, shouting, "That's Martez Anderson, he's the best." Very calm. Did she seem like she wanted to identify him in court? Did she seem like she was having a good time being here? She's pulled in under oath and made a very calm, casual, deliberate identification, which, by the way, even after cross-examination from this defense attorney, very good defense attorney, okay, did not waver one bit in that identification of Martez Anderson confronting Miles in possession of a handgun. Didn't waver one bit. She described, consistent with the other testimony, consistent with the other evidence, that he took that gun in his hand, the defendant, and that he attempted to hit or pistol whip Martrell Jackson with that gun. Consistent with the other evidence. She then turned around and she began to do what? Run. Is that inconceivable when someone has now escalated this context from a very violent fight up to a lethal context? She sees a gun, this kid's out there, she turns and runs, she hears the gunshots. She did not come in here with her cymbals bashing, "He's the shooter, I saw him, he did this." If she wanted to make this up, if she really wanted to come in and jam him up, right? "I'm gonna lie, I'm gonna get this guy, I have some sort of reason." That's what she would do. She saw that gun, she turned around, and she heard gunshots. That's it. But that's critical testimony because it places the defendant there. It gives an identification of this defendant. It puts a gun right in that defendant's hand. It proves that he swung that gun at Martrell Jackson. And it is contemporaneous with what we know happened, the final lethal assault using that gun. Does she have a special reason to lie? I mean, she's either telling the truth or she's lying, all right? So what evidence was elicited that she had a motive, a bias, a reason, any other? Why? Why not blame someone else? Why not say she didn't see anything? Right? And all of that is part of the credibility and identification instruction. As you look at identification, one of the things that you have to look at is, you know, how long was she watching? Well, she watched that entire incident. She knows exactly who's in what fight. She watches him pursue him down the sidewalk. Does she know the person? Yeah. She doesn't just ID him, she knows him. Okay, if you walked outside on the street and you saw me hitting somebody or pistol whipping somebody, you say, "Yeah, I don't know what suit color he was wearing, but I know that guy, that's Crino." Human beings are not great identifiers, but we're really good recognizers. And she recognizes this person as someone she knows. There was questions about the lighting. Okay, well, we're going to see Officer Pulver's body camera in a few minutes, okay? When he responded to that location. The lighting's just like that. It's an apartment complex. There's lights everywhere. It's mandated by law that it's lit. There's lights in the parking lot. You're going to see lights overhead the parking structure. You're going to see lights on the different buildings. You're going to see the color of what it looked like. It was certainly lit enough for her to make that identification of the defendant. And guess what? The last fact is this. Her identification matches exactly with all of the evidence in this case. All right, the next person we want to talk about is Miles Washington. And I want to talk about Miles's identification in this case. Miles described to you, picking up his description at 144 of the video when he begins walking backwards. This fight is now done or should be done. And again, I've used that word fight, and it is not a fight. This assault, this violent contact is done, and it should be over, but it's not. because the defendant and at least one other male continue to pursue Miles. Why? Because they want him. They're coming after him. It's right, that wasn't enough. That beatdown was not enough for whatever transgression happened, okay? They want him, and they're coming for him. And Miles identified that as he backs up to the parking lot, at least two men begin to follow him. He describes one man as a shorter, heavier set man. He describes the second man as a tall, skinny black male with dread-style hair, a black jacket on top, and black pants. I want to pause for a moment with that description. There's been lots of questions in this case about, well, there was other African-American men there was other people who had dreadlocks, there were other people who had dark hoodies on, and I, with the utmost respect to my wonderful colleague in this case, I know that there was nothing inappropriate meant by that line of questioning. It's about identification, but understand this, ladies and gentlemen, people are more than the sum of their parts, okay? So African-American people with dreadlocks and hoodies on, okay, that's not their only physical feature. People have builds and size and heights and the way they carry themselves and facial structures and smiles and all kinds of different features. That would be like saying that Mr. Austin and I are both middle-aged white people with blue suits on, where that's completely different, okay? So understand, like, yes, there were people there, but I think Ms. Williams said it the best. It was a very diverse crew. And she knew Martez. But again, this is the identification that Miles gives. And Miles tells you that as these two men begin to approach, one of those men has now a gun in his hand, a gun that we have not seen before. And assuming our identification is correct, and we believe beyond a reasonable doubt that it is, you can see this defendant tugging on his hip the entirety of that night, can't you? That is a concealed weapon, ladies and gentlemen, and now that weapon is out. And what does Miles Washington tell you that he does? He takes that and he tries to pistol whip Martrell Jackson, and that's exactly consistent with what Anea said, and it's exactly consistent with what Martrell said. And he said that he tried to intervene and he tried to swing on this man, and then he sat there in open court and he identified the man who had that gun in his hand as this defendant, Martez Anderson. But there's more. When he swung at him, he described that this defendant right there, Martez Anderson, stood, he pulled up that gun, he pointed it directly at him as we've talked, and he began firing that gun directly at him. He has positively identified the shooter in this case as Martez Anderson. And as we look at the credibility instruction in this case, does Miles Washington have any reason to lie? Did anything come out on extensive cross-examination? It's got a beef, a problem. He does not even know him. He's never met him. No reason to lie, no beef, no problems, no nothing. He could identify Mickey Mouse up there. He chose to identify this person. Why? Because he told you that he was very certain of what he observed. And guess what? He was looking right at him when Martez shot him. The other important thing to understand is, despite all of the cross-examination that this experienced attorney leveled on this 21-year-old man testifying to you in a room full of adults in front of the person, by the way, who shot him, okay, he never in this exam, wavered on his identification. Never. And the final thing to understand is, ladies and gentlemen, it is exactly consistent with the other eyewitnesses and evidence in this case. As we look at the identification instruction, however, one of the things that you, of course, must analyze in your deliberations is the fact that on the night in question, in the hospital, Miles said it was the heavier set man that shot him. So, of course, that's going to be extremely important for your deliberations in this case. But let's talk about the context of that before we get into our conclusions about it. You were shown what's called a recorded recollection. You're going to be instructed on that. And what a recorded recollection is a piece of recording from what Miles said to the police in the hospital. Please focus on the context in which this was said. The time on that recording, we were very clear, is what? It was 4:34 in the morning, 4:34 a.m. just give me a moment here. And I want to show you something. I want to show you Officer Pulver's body cam, please. All right, we see in this clip from Officer Pulver's body cam a lot of really important information. First of all, we see Martrell Jackson, who we're going to talk about in just a moment, right in that video, right with his friend. Secondly, ladies and gentlemen, take a look at the lighting. If you want to know what the lighting was like down there, this is probably the best representation, okay? It is well lit. There are lights. Watch as Officer Pulver approaches both in his vehicle and on foot. You're going to see lights from the parking structure. You're going to see overhead lights. You're going to see lights and street lights down there. So this is a good indication of what the lighting was like. The third thing you're going to see, ladies and gentlemen, is this. Miles Washington is now down on the ground, shot, bleeding, as we know his condition was. And what time in the morning is that? That is 3:25 in the morning. So when he gives his statement to the police at 4:34, an hour and 9 minutes earlier, that was him. And what had just happened to him, as we know? He had been kicked, hit, beat, stomped, chased, shot 3 times, left on the ground, bleeding, puddles of blood everywhere. Lansing Fire Department arrives on scene, throws him into an ambulance. His family's there. They're freaking out. There's a confrontation with police. They rush him off to Sparrow Hospital emergency room. He's taken into the emergency room. Dr. Fracticelli said he would have had extensive pain from this. He likely would have been in shock from this, ladies and gentlemen. That's the context of which he was in at that time, but there's more. We know that when Officer Fox made contact with this young man in the hospital, this is what he looked like. He was hooked up to oxygen. He was in a hospital bed. He had a tourniquet on his leg. He had 6 gunshot wounds in his leg. He was lying in a pool of his own blood. And guess what, ladies and gentlemen? At 4:05 in the morning, okay, 30 minutes before that interview that you were shown in this case, he was given what? Fentanyl, which is a very strong opioid. You know, the one that makes people bend over in the park outside? He was given that narcotic 30 minutes earlier. So that statement, you have to consider the context of that statement. When he made that statement, ladies and gentlemen, all of that had happened to him right up until the point where he had fentanyl. In fact, this very experienced detective went in there about an hour later and she said he was crying like a baby. He was unable to formulate any thoughts. He never should have been interviewed that night. And I want you to just flip this for a second, ladies and gentlemen. Let's say that was my identification testimony that I produced to you in this case. Folks, I got the shooter. Here he is. This guy in the hospital who just got his ass kicked for 2 hours and then got shot and was given fentanyl, he just made an identification. Please find it reliable. You would laugh. So yes, he made that comment, but he doesn't even remember making it, and you must consider the circumstances and that it does not agree with any other evidence in this case. And lastly, ladies and gentlemen, when you consider it, remember this. What Miles said was not, I got chased by the fat guy and he shot me. The officer asked him, so you're not sure whether it was the tall, skinny guy or the fat guy that shot you. So he's still making those 2 individuals who he's identified acting jointly with one another. How does the identification progress in this case? Well, we know that after he gets out of the hospital on December 16th, he goes and sees Detective McGonigal. She's not facing anything. No one's been arrested or charged based upon this identification. He is lucid, he is feeling better, he is a whole different human being when he goes in there to see her. And does he go in there and say, no, I know who I'm gonna get Martez Anderson? He doesn't even know the guy's name. He goes in there and he gives her the accurate description of the shooter and provides her with social media information. And then this detective continues her investigation through social media and through witness interviews and through looking at videos that she obtained from Lewandowski and looking at fight videos. And it's that way that the identification is made. This defendant is charged. And then on August 23rd, a preliminary examination is held under oath. Miles Washington identifies this man, Martez Anderson, at that time, just 6 weeks after the shooting, as the person who shot him. And again, it matches all of the other evidence in this case. The final witness we want to talk about, and I should be done in about 15 minutes, is this. Martrell Jackson, a really interesting witness. A couple things we want to say about Martrell and Anaya. You know, the world that I opening my closing remarks with, this world where nobody has the decency to stay, no one has the decency to talk to police. There's really one guy who did. You know, Martrell Jackson stayed with Miles the whole time. He stayed on scene. He took off his green shirt and laid it over his buddy. He and Anaya tried to staunch the bleeding. They did the right thing. He then gave an immediate statement to Officer Pulver, right standing next to Miles when the Lansing Fire Department rolled up, okay? And it was at that time that he did what? He identified the description of the shooter right then. No chance to fabricate, no chance to make it up, no conversations with Miles, no conversations with Anaya. Right at that point in time, he made an identification of the shooter. He then stayed on scene. He was put into a police cruiser and he gave information to Officer Pulver. He showed him his head that had been cut. And then he took him down to the police station and he was again cooperative with the police. So as we look at the credibility of this young man, understand that he's the one that stayed. He's the one that has done the right thing. He's the one that has come into court, albeit unwillingly. He doesn't want to be testifying up there. That was obvious. And made an identification. So with that context, let's look about what Martrell said. He again corroborated that the fight ended. He and Miles were walking together backwards towards the car. He corroborated that at least two men continued to follow him, a taller black male, okay, in a dark hoodie and a heavier set male. He described to you that they continued to talk smack or continued to talk shit or whatever the words he used, excuse my language, okay? And he said that at some point in time, the taller male had something in his hand again, and he described that as a handgun. He told you that that taller man then began to swing that in a manner as to pistol whip him, exactly consistent with the other testimony in this case. And he identified that individual with the gun in his hand as this defendant, Martez Anderson. He then described to you, consistent with Miles Washington, that the defendant, Martez Anderson, pulled up that handgun, pointed it directly at Miles, and began shooting at Miles, and then did shoot Miles. He specifically, positively identified to you in open court that this defendant, Martez Anderson, shot Miles. He was questioned extensively. One of the things we thought that was so critical about his testimony, and perhaps you can talk about it when you go back into the jury room, before the people even asked for an identification, all right? We didn't ask who this person was. We didn't say point this person out in court. We didn't say anything like that. The question was, what did you think about this guy jumping you or beating you up with all the other guys attacking you at the same time? And he said, what? Soft. And we mentioned on the record, when he said soft, what did he do? He looked directly at that defendant right there. People didn't ask for an identification. I didn't say who did it. But what did you think about being jumped by all those people? He looked right at that defendant and he said soft. Do you think that this is not a person who knows exactly who it was that jumped him and shot his friend? Oh, yes. Martrell was questioned extensively about this incident by this very experienced defense counsel. At no point in time did he ever waver one bit that the guy who swung the gun and the guy who shot Miles was in fact the defendant, Martez Anderson. Never wavered. And ultimately, no reason could ever be elicited as to why he would make this wrong identification. They don't know each other. There's no prior beef. There's no prior problems. Doesn't even know him. He's either making this up for some reason, or he's being exactly consistent with all the evidence in this case, and no reason was ever elicited for bias or prejudice, a reason, a beef, a problem. And we submit to you, though he was hesitant and though he didn't want to come in here, was obviously he didn't want to point at anybody, okay? He said, I know, I'm telling the truth, okay? It was clear that he both knew and identified the individual that pistol whipped him and shot Miles Washington. The second critical factor, I think, from Martrell Jackson is this. Martrell Jackson identified that the person who came up to him on the porch and started the whole fight, that's the same guy that shot Miles Washington. Well, what do we know from the video about the guy who comes up and starts the fight with him? The video doesn't lie. Tall, black male, hoodie on, sweatshirt, white markings, very ornate pants. All right, so that guy who started the fight, that's the same guy who shot him. Okay, so let's look at this for a moment and go back and take a look at this, because there's more. Oh, there he is. So he identified that person, ladies and gentlemen, that person who started the fight, that's the one who shot Miles, okay? And I want to take you back to this. The most telling factor of his testimony was this. He stayed on scene. He made an identification to police. He told them who the shooter was, identified him right there. No chance to fabricate, no reason. It's in the panic of the moment. And what did he identify to the police? That the shooter was black male, slim build, black shirt with white graphics on it, and black pants. It's a pretty good identification of exactly who we know in this case is Martez Anderson. In short, ladies and gentlemen, a reasonable doubt is just that. It is a doubt based on reason and common sense. All three of the eyewitnesses in this case, without any type of motive to fabricate, without any bias, without any prejudice, without any prior knowledge, all three of those individuals identified that Martez Anderson was present at the party, that he confronted Miles and Martrell, that he had a gun in his hand, that he tried to hit Martrell with that gun, and then two of those eyewitnesses identified that this defendant pointed that gun and repeatedly fired it, shooting Miles Washington on the street that night. As we conclude, ladies and gentlemen, police did not just rely on eyewitness testimony. We saw an outstanding cooperative investigation that was done by the Lansing Police Department with road patrol officers, this detective, Martha McGonigal, crime analysts, etc. And what are some of the highlights of that? Well, we know, ladies and gentlemen, that the forensic examiner was able to find a video on the defendant's phone that was sent to him just after, or opened just after midnight on the 7th, about 3 hours before the shooting happened. Looks like it's daylight in this video, so a very strong inference from that is that that was sent, or that was him that day, the 6th, leading into the 7th. Well, what do we see as we watch this video? All right, we see a defendant, in this case, with long black dread-like style hair, a black hoodie on, with a white moniker on the front. And not only is there a white moniker, but it's a very distinctive white moniker, which says Coffee and Chaos. That sweatshirt, that matches identically the sweatshirt of the person that Martrell said assaulted him on the porch. That moniker, Coffee and Chaos, that's on the back of the shooter's sweatshirt. That's highly probative evidence, ladies and gentlemen. What else did we find? We found, ladies and gentlemen, that at 3:25 in the morning, when Miles was laying on the pavement, remember that? On his face in a puddle of blood, maybe dying, maybe bleeding out, 3:25. That same time, 3:25, on this defendant's phone, he receives text messages that said, we're gonna drop Keyshawn off, come back and grab you, after he has location shared. And then at 3:25, the text goes to him, hide, bro. Well, it would seem to me, ladies and gentlemen, on behalf of the people, that you only have to hide when you did something. Okay, we're not playing hide and seek at 3:30 in the morning in the city of Lansing. It sounds like we're hiding because we are conscious of what we just did. And that matches the testimony that what we just did was shoot somebody on the street. But there's more. We know that Mr. Lewandowski lived just one street away from 6255 Beachfield Drive. And we know, ladies and gentlemen, that he was kind enough to prepare this video log for us, and all the videos are in evidence. And we know that at 3:25, when the defendant is supposed to be hiding, bro, the police cars are running by Mr. Lewandowski's house. And we know that at 3:29, ladies and gentlemen, we observe a man run by his house. That person appears to have long dread-like style hair consistent with the photograph that we took off his phone from that day. That person is wearing obviously the exact same pants that the person who starts the fight at the party is wearing. But he has now altered his appearance because the sweatshirt is off. And why is that important? As we play the video clip here. So sirens are wailing, hide, bro, one street over. And we see someone identically matching the description of this defendant running. And not only has the defendant been running, but we know the defendant has been on the side of the house doing something and is now running past the house, and then is now jumping over a pool fence, and is now jumping over another fence and going to another location. This is not the conduct of someone who has not just committed a crime. It is a consciousness of guilt, ladies and gentlemen. This defendant is running away from the police who are investigating the shooting that he just perpetrated. He has altered his appearance. He is running in an erratic fashion. What possible reason could there be for him to jump over Mr. Lewandowski's fence and in the backyard? But there's more, ladies and gentlemen. Even if you want to think, well, hey, maybe that's not this defendant because he doesn't have the sweatshirt on. Well, we know, ladies and gentlemen, that the next day at 5:11 p.m., someone who looks a whole lot like the defendant is dropped off at that residence, and he goes there and has a real interest in Mr. Lewandowski's window wells. And he is looking for something in the exact location that the person the night before was hiding. And how do we know that it is in fact this defendant other than just looking and making that comparison? We know at 4:47, he is dropping a pin to someone that they're ready to go, and he puts 6145 Norburn Way in the city of Lansing, 48911, even in the United States. It would defy all sense of reasonableness that this defendant was not at the house the next day, and was not at the house the night before, and was not fleeing from the police for what he had done. Hide, bro. Ladies and gentlemen, as I conclude, I want to say two things. First of all, the evidence in this case beyond a reasonable doubt establishes on the night in question that Miles Washington was repeatedly assaulted in a manner to cause him serious or even great bodily harm, less than murder. There was an escalation of that. A gunman who we've now identified as the defendant, Martez Anderson, produced a gun. It was concealed on his person. Prior to producing it, he held it in his hand. He attempted to attack or assault Martrell Jackson with that dangerous weapon, but not in a lethal way. He then lifted that gun up, and this defendant, Martez Anderson, fired that gun repeatedly at Miles Washington in a manner that we believe the evidence shows beyond a reasonable doubt is consistent with an intention to kill. That meets the burden of proof beyond a reasonable doubt on the charge of assault with intent to murder and felony firearm, carrying a concealed weapon, and felonious assault, which will all be defined for you. But there's one thing we want to add to you, ladies and gentlemen, and again, I can't stress enough on behalf of the people, we believe that this defendant was in fact the shooter, that the evidence shows he was the shooter beyond a reasonable doubt. But we are mindful, okay, of the fact that Mr. Washington in the hospital indicated that there was a tall, skinny man with a gun, and that there was a tall, skinny man, and that there was a heavier set man, and it was the heavier set man that shot him. Let's say you want to reject everything that the people said. Let's say you say, none of this, I don't care about all of the evidence that matches perfectly and the credibility of this identification testimony. I want to base my case solely on that statement that Mr. Washington made to police at 4:34 in the morning, right? And remember, that statement was not, there was only one man and he was tall and he was fat. That statement is, are you confused as to whether the tall, skinny one or the fat one shot you? Okay, that's the statement, all right? But if you want to conclude that this defendant was in fact the tall, skinny one, and there's ample evidence from Anaya and Martrell and from Miles to support that, but it was actually out of the blue, the fatter man that shot him, that does not mean that this defendant is still not culpable as an aider and abettor. So you may consider that instruction. Again, that would be a secondary theory for us, but that is not our primary theory in this case, because our primary theory is that this defendant was in fact the person who had the gun and was in fact beyond a reasonable doubt who shot Miles. But to the extent you want to consider that, you will be instructed in this case that the defendant is charged with committing the crime of assault with intent to murder, or the lesser crime, and you'll hear about that later, of assault with intent to do great bodily harm, or intentionally assisting someone in committing it. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abettor. And the following elements must apply. First, that the alleged crime was actually committed either by the defendant or someone else. And it doesn't matter if anyone else has been convicted for that crime. So if you believe that someone else assaulted Miles with the intent to murder him or the intent to cause him great bodily harm, as long as you find beyond a reasonable doubt that that crime was committed, you may move to the next element. Second, that before or after the crime, before or during the crime, the defendant did something to assist in the commission of that crime. We voir dired about this, didn't we, ladies and gentlemen? We talked about that movie, The Accused, many years ago, where someone perpetrated a sexual assault on somebody. Some people stood around and they cheered, okay? Some people blocked the door. All of them were participants as aiders and abettor to that principal who was doing the sexual assault. Another example might be if two people go to beat somebody up, and they beat them very badly, and then one of those actors produces a weapon and shoots them. They are aiding and abetting one another. They are assisting one another. They are encouraging one another. How, if you believe the other man's the shooter, and again, I can't stress enough, that is not our position, but to the extent you believe that, how would this defendant be assisting? Well, ladies and gentlemen, this entire event was jointly participated in. This was a joint assault, a joint escalation. This defendant jointly continued to pursue Miles. This defendant was in possession of weapons. This defendant pulled out a weapon, and then there was a shooting. That is assistance as defined by Michigan law for purposes of being an aider and abettor. And the last thing you have to consider is any shared intention that might exist. First or third, at the time the defendant intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the alleged crime is a natural and probable consequence of the commission of the crime intended. Take a look at those intent elements to the extent you want to think that the heavier set man was the shooter. Is it a natural and probable cause that when you go to a conflict armed, beat someone within an inch of their life, pursue them together with another person, pull out your weapon, try to hit somebody with it, be in possession, and is it a natural result that there could be a lethal assault here? We believe beyond a reasonable doubt that the evidence shows you in this context, of course. So while this is not our primary theory in this case, you will be so instructed by Judge Aquilina, and you may consider aiding and abetting. But we urge you, ladies and gentlemen, to essentially discount that prior identification as unreliable. Look at the identifications that were made by Anea, by Martrell Jackson, in court by Miles Washington. Look at the totality of the evidence. Look at how it all fits together, supports that this defendant was the shooter. We talked to you in opening statement about holding this defendant accountable. Why do you want to hold somebody accountable, ladies and gentlemen? Well, you know, what happened in that world on the night of July 7th, 2024 was simply unacceptable. It was unacceptable to attack this young man. It was unacceptable to beat him the way it was. It was unacceptable to pursue him. It was unacceptable to pull a weapon out, to be in possession of a weapon. And it was absolutely unacceptable to shoot him like an animal on the street and allow him to lie there until he may or may not have bled to death. And I, on behalf of the people, am asking you to hold this young man right there accountable for his actions that night. And the people are asking that you hold this defendant accountable with a verdict of guilty of assault with intent to murder, guilty of felony firearm, guilty of carrying a concealed weapon, guilty of felonious assault or assault with a dangerous weapon, and guilty of a second count of felony firearm. I'll have one more opportunity to speak to you again in my rebuttal. On behalf of the people of the state of Michigan, thank you so much for your time here this morning.
Does anyone need a break? Seeing no hands raised on behalf of defense.
Thanks, Judge. Mr. Carino. Good morning, ladies and gentlemen. As a juror, you are empowered to do justice. Now, you may recall that I told you in my opening statement that Mr. Anderson walked into this courtroom an innocent man. And I'm just as confident now as when I said it then that he's going to walk out of those doors the same way he came in. Just as the burden of proof never shifts, ladies and gentlemen, the presumption of innocence never leaves either. Your verdict must be based on evidence. Strong, reliable, credible evidence, not possibilities, not speculation. They had no more desire to look at the evidence in this case than they did to stare directly into the noonday sun. If they had looked at the evidence in this case, I'm confident that they would have reached the decision that I'm sure that you folks will soon reach. That there is, at a minimum, a reasonable doubt in this case. And to reinforce some of the things that I told you in the beginning of my opening statement, I talked about some of the things that you would not see in this case. And despite the video evidence that has been presented to you, I told you that you would not see any photographic or videographic evidence that showed the shooter in this case. Certainly you did not see any photographs or video evidence showing that Mr. Anderson shot Mr. Washington that night. There was no firearm that was presented to you that was collected by the police that they were able to tie to the shooting of Mr. Washington. Certainly they didn't present any such firearm to you that was used in the shooting that was traced back to Mr. Anderson in any way. That is important because you will be instructed that reasonable doubt comes not just from the evidence, but also from the lack of evidence. What eyewitness testimony we do have in this case is riddled with discrepancies and inconsistencies to the point that it is not to be believed. And I'm going to discuss some of that a little later with you in more detail as I carry on in my summation to you. I'm going to start with Jordan Glover. People talked about him and his testimony to you in their summation. He was the host of this party. It was meant to be a celebration of his birthday. Some interesting things about his testimony, and people even alluded to this, that doesn't seem that they're disputing. He didn't invite Mr. Washington to his party, but you know who he did invite and extend an invitation to, at least through one of his other invited guests, was Martez Anderson. As Mr. Glover stated, he allowed another one of his invited guests to bring a guest or guests with him, which turned out to be Mr. Anderson. He acknowledged that during my cross-examination that Mr. Anderson was there with his permission, although he didn't really know who Mr. Anderson was. Mr. Glover was there amongst the crowd that night, and two things that stuck out to me that I would ask you to concentrate on. He never saw Mr. Anderson with a gun. There was no testimony of that. He certainly never saw Mr. Anderson fire a gun or shoot anyone that night. Now, turning to Mr. Washington, I want to make some things clear. I certainly believe that Miles Washington is a victim, and I'm not going to pretend otherwise. I'm not here to tell you that he wasn't shot. That would be ridiculous. I'm not here to tell you that what happened to him was legally justifiable. What I'm here to tell you is that Mr. Anderson did not shoot him, and that there is no credible evidence that he did. And certainly they haven't proven to you that he did beyond a reasonable doubt. Some very key things to take away from the testimony of Mr. Washington. We know that minutes after the shooting occurred, when the memory of the events would still be presumably fresh in his mind. This is very important when he was speaking to law enforcement. He's speaking to Officer Fox in the hospital. Keep in mind, Mr. Washington, describes Mr. Anderson as a young, skinny African-American man. But he made it very clear, as I brought out on my cross-examination with that recorded recollection. Yes, Officer Fox was trying to clarify with him and pinpoint him down, but he wasn't waffling on that. It was the short, fat guy that shot him. He was forced to acknowledge that under cross-examination after I confronted him with that recorded recollection of him making that statement to the police. And now he's trying to tell you, they're trying to convince you that his follow-up stories and identification of Mr. Anderson is actually the true version. They would have you believe that Mr. Washington was under the influence of medication to the point that I don't know, he was misremembering what happened to him moments later. It was somehow confusing his memory as to who did what to him. But keep in mind, Mr. Washington was trying to say he didn't remember any of that. He didn't remember what he initially told the police. He didn't remember speaking to the police that night in the hospital. And again, this is approximately an hour and 15 minutes or so after he was shot. Well, when all of a sudden did his memory get jarred to the recollection of these events? Because on that very night, within an hour and 15 minutes or so, he's talking to the police. Again, this is very critical, when presumably the memory of the events would be most fresh in his mind. He was speaking to the police. And he says it was the short, fat guy that shot him. But If all of that is caused by whatever medication that he was given to the point that he doesn't remember any of that, doesn't remember speaking to the police, doesn't remember what told him, well, then how can you believe his subsequent version of the events? How can you believe his subsequent identification as to the person who actually shot him was? The answer to that is you can't, and you shouldn't. When all of a sudden did his memory come back to these events, when moments after that, apparently he has absolutely no recollection whatsoever of speaking to the police, what he told them, or any of that? How can anything that he would have said subsequently, days, months, or a year and a half later, be credible? It's not. Why is Mr. Washington now saying it was Mr. Anderson that shot him? Well, I think there could be a number of rational explanations for that. One key thing that stuck out to me that came from his interview with Detective McGonigal, which I believe was about a week and a half or so after the shooting, was about how he had provided her with or was able to identify some social media account of who he believed the person was that shot him, which was Mr. Anderson. Now let's think about that for a minute and why this is important, why this is critical. Remember, Mr. Washington didn't know Mr. Anderson that night. Didn't know him, never met him, never heard of him, didn't know who he was, didn't know his name or really anything about him. Exactly how could he have come across his social media accounts? Are we to believe that he was just scrolling through Facebook or Instagram for hours and hours on end until he just happened to come across the profile? Oh yeah, I think that looks like the guy. No, that doesn't make any sense. What that suggests is that someone must have told him that or planted that idea in his head. Otherwise, how could he have just stumbled upon that? How could he have just happened to locate that? It's because someone, we don't know who, didn't come out in evidence, planted that seed in his mind that it was perhaps Martez Anderson. That's the only rational explanation, is how he would have just happened to come across that. Could that have influenced him in his subsequent identifications in some way? I think so. Could it be possible that since Mr. Anderson is the one that was subsequently charged and the one that is facing trial here for these crimes, that maybe he thinks, well, I guess they must have got the right guy, and maybe he's now too ashamed or too embarrassed to admit that, given that that's the complete opposite of what he initially told the police in the hospital that night, shortly after the shooting. You'll notice that he was extremely hesitant to own up to anything that might make him look bad in any way. I had to drag it out of him. He didn't want to acknowledge that he initially told the police that it was a short, fat guy that shot him. He didn't want to admit that he told Detective McGonigal that the shooter and some other suspects put on masks right before those shots were fired. Remember that exchange? He claims he didn't remember that either. You'll remember I actually had to show him a copy of the police report to refresh his memory on that. And then he still didn't admit it. Nope, don't see it there. Didn't say anything about that. Don't know what you're talking about. For a moment, I almost had a low-key panic. I thought maybe I gave him the wrong page or something. No, he just didn't want to admit that that's what he said, until I actually had to show it to him again, and I even highlighted it for him. Even then, he was kind of wishy-washy about it. Well, I guess I did say that. I don't really remember, but I suppose I did. Remember the countless times that I asked him questions And his response was either, I don't know, or I don't remember. I lost count, but I know the record will bear that out. How can you trust the testimony of someone that repeatedly says he doesn't know and doesn't remember? Doesn't remember things, doesn't remember what he previously told law enforcement. How can you trust the testimony of someone that changes their story, that leaves things out that isn't forthcoming, or when presented with evidence of prior inconsistent statements, they still don't want to admit it? You can't. It's not credible. It is not to be believed. That is a doubt. That is a reasonable doubt, and a reasonable doubt compels you to render a verdict of not guilty. Keep in mind that this is someone with personal firsthand knowledge of these events. And apparently, he can't even agree on what the facts of the case are. How can you, as the triers of fact in this case, determine what they are through all that? You can't. And again, that is a reasonable doubt. While we're on the topic, let's talk about the mask that Mr. Washington apparently told the detective that at least multiple suspects put on just before the shooting. Did you hear any testimony from any other witnesses that supported that? Did you hear anybody else say that or say anything even remotely close to that? No. There was not one witness that said anything about the shooter or anyone else putting on a mask or a ski mask that night. I can see why Mr. Washington would be reluctant to own up to that, because it doesn't make any sense. It doesn't make any sense at all. Why would anybody all of a sudden, in the middle of this big melee where Mr. Washington is getting pummeled, when it's summer, countless people have already presumably seen whoever is involved in this, but apparently they put on masks, or somebody put on a mask, but apparently not to the point that it obscured their face in any way. Because we can still see in the video, you can see the sides of the face, and even the detective admitted that. Nobody had on a mask. Certainly no one pointed out that Mr. Anderson had on a mask in that video to the point that, it obscured his face. Well, again, what sense would that make? It doesn't make any sense. And keep in mind all these discrepancies, all these inconsistencies, and all these nonsensical statements, such as the initial identification and the description of the shooter being the short, fat guy, suspects putting on masks just before the shooting. Keep in mind, these were statements that were brought out on cross-examination, statements that you would have not known about had I not asked about them. We weren't about to tell you. They didn't come out on direct. I had to drag that out of all those things out of Mr. Washington. So let's talk about Anaya Williams. We know that she was formerly in a relationship with Mr. Washington. We know that she either accompanied him or drove him to meet with the detective for his interview approximately a week and a half after these events. We know that they rekindled their relationship sometime either contemporaneous with or shortly after this incident. Could she be saying that it was Mr. Anderson in order to support Mr. Washington, or because she wanted to be supportive of Mr. Washington? Even if they're no longer in a relationship now, she knows she's locked into that story that she initially told law enforcement. She certainly wouldn't want to change her story now, even if she has doubts about it. I think that is a possibility. That is a reasonable possibility. That is a reasonable doubt that again leads to a verdict of not guilty. Keep in mind that all of these events happened well after midnight. Despite whatever lighting that was out there, it was still relatively dark. This was an unexpected event. This was a party atmosphere, multiple people drinking. There were dozens of people there, a lot of people milling about, doing various things, when all of a sudden this startling event occurs, very frightening to everyone. It would be easy to see how in the midst of all this sudden chaos and confusion, that maybe there was some mix-ups as to who was who or where, what they were doing. I mean, you've seen how jumbled everything and how chaotic that entire situation was from those videos that we have just seen over and over again. It's not beyond the realm of believability at all. It's very plausible, very likely, and it's very reasonable. Now, and I don't want you to think that you have to be assigning some kind of nefarious motives to the witnesses in this case in order to either disbelieve them or order to render a verdict of not guilty. You don't have to believe that they are necessarily deliberately lying, or you don't have to believe that they're all involved in some type of massive conspiracy against Mr. Anderson. They could very well honestly believe what they are saying, but for a number of reasons, whether it's because they're genuinely mistaken, they want to believe it, or they have been influenced either directly or subconsciously to believe it and still be wrong in those conclusions. So I don't want you to think that you have to believe that they're deliberately lying in order to discount their testimony or to have a reasonable doubt about their credibility, because you don't. Same with Martrell Jackson. We know he's a friend of Mr. Washington. I think the same rationale that I previously discussed could be applied to him. He could be lying, he could be mistaken. Perhaps he's saying Mr. Anderson is the person that's involved because that's what he's been conditioned to believe, or because that's what he wants to believe. What I do know is that his testimony is not credible, it is not trustworthy, and it is not to be believed. He admitted to being intoxicated that night. Intoxicated off of one shot, mind you. Now that's either a very powerful shot of whatever it was that he took, or he's lying about how much or what he had to drink as well. And if that's the case, and it seems that he is, it seems that it is, then what else is he lying about? What else is he mistaken about? Again, that's reasonable doubt. Now, let's say you believe Martrell Jackson or Anaya Williams when they say they saw Mr. Anderson with a gun that night. Let's see where that leads us. That still doesn't mean that he fired the shots that night at Mr. Washington or anybody else. And even Anaya Williams acknowledged that she did not see him fire. She did not see him shoot anything. Are we to believe that Mr. Anderson was the only one in the crowd of dozens that night carrying a firearm? Are we to believe that he was the only one with a firearm in the crowd of 8 or so, or however many it was, that was engaging in this brawl against Mr. Washington? Not only is it possible that multiple others had guns that night, but I'd say it's likely. Could one of those have been the one who actually fired the shots that night? Even if you believe that Mr. Anderson had a gun, and I'm not saying that he did, and I'm not saying that the testimony or evidence that he did is credible, but let's say you believe that. That doesn't mean beyond a reasonable doubt that he is the one that fired the shots or shot Mr. Washington. That would certainly explain why no such gun was ever recovered. Just maybe it's still in the possession of the person that actually fired, not Mr. Anderson. Keep in mind that it only takes a second, or maybe a fraction of a second, to pull out a gun and discharge it. It certainly isn't unimaginable that could have happened so quickly, in a split second, amidst the darkness and chaos that night. And keep in mind the time gaps on that video that depicts the shooting that we've seen and talked about before those shots rang out. When the physical assault and the pummeling was dying down, that is an awful lot of time. And again, it just takes a very quick, brief moment for someone else to pull out a gun and fire. What if you believe Mr. Jackson? What if you believe that Mr. Anderson had a gun and pistol whipped Mr. Jackson that night? And you believe that he committed that assault against Mr. Jackson with a dangerous weapon? Does that mean he's guilty of the other crimes that he's accused of as well? No, absolutely not. And we discussed this during voir dire. These are all separate counts. They're separate offenses with separate elements, and they must be analyzed and evaluated separately and individually, not collectively. So even if you believe that Mr. Anderson committed that assault against Mr. Jackson, that does not mean you get to go and automatically vote guilty on all the others. You cannot do that, because you have to look at them separately and analyze them separately. You have to look at the facts as you determine them to be and look at those elements separately. So again, even if you believe Mr. Anderson committed that assault against Mr. Jackson, I still urge you to carefully consider the other evidence when evaluating the other counts. And I would ask that you render a verdict of not guilty for the various reasons that I've stated. Now, we have seen many times those videos from the party that depict what went on that night. We have seemingly gone over those almost frame by frame. It seems like a countless number of times. But you are the triers of fact in this case. You get to decide what the facts are. You don't have to accept what any witness says about what they believe that they saw in those videos. You will get to watch them and draw your own conclusions. You get to determine what you see in those videos and what significance you attach to it. Now, at times I thought they must have been watching a different video up there when the detective was testifying, as they were pointing out in minute detail about what she was supposedly seeing in that video. This body movement, this decal, this writing, this color, this supposed mask, glasses on the face of this person, which was something that didn't come out in direct, by the way. That was a new thing they added on redirect. Going through the smallest amount of details, all the while wondering, how is it possible that they're seeing all of that? So again, you will get to watch those videos and draw your own conclusions. You get to be the triers of fact. You don't have to accept, and I would urge that you not do so, what another witness claims to have seen or what they believe that they're seeing in that video. But we also saw in those same videos the numerous partygoers who were there, many of them out with their cell phones out, recording. Suddenly then, she couldn't see what was plainly front and center on that video. Everybody in this courtroom knew what they were doing. I don't know what they were doing. I can't tell. I can't see. Maybe they were doing that. I don't know. I can't really tell. It's quite obvious that that's what they were doing. Of course, a bunch of young people are going to be recording a situation like that. They see what they want to see. Why is that important? Because there are a countless number of witnesses in close proximity to when those shots were fired who likely captured it on their cell phones. But apparently they couldn't be bothered to ascertain who those people were or to track them down. Well, we put something up on Crime Stoppers. We didn't get any hits. I guess that's all we could do. They didn't seem to have any problem finding and producing the witnesses that they wanted to find and call, and that they actually did produce on the witness stand, because those were the witnesses who fit their narrative of the events, or so they thought anyway. It's very likely that the actual shooting and the identity of the shooter was captured on one or several of those cell phones, and it would have exonerated Mr. Anderson. But we don't have that evidence because they failed to find it, or in my opinion, even put in a good effort in locating something that any one of us would have thought of or tried to do. Wasn't really discussed in the people's summation, but it was brought out during testimony. Again, when we were watching those videos about, they're claiming that Mr. Anderson is on that video and that he's checking his waistband. Now, they kind of left it at that, but I think the implication that they're trying to imply or insinuate is that he was doing that and he was reaching for a gun or was ready to pull out a gun and fired upon Mr. Washington. And again, the detective was being rather evasive when I was asking questions about that. You can see for yourself that that person in that video, those pants they were wearing were very loose, even exposing the person's undergarments at times. So even if you accept that is Mr. Anderson, then it's not only plausible, but more likely he was checking his waistband because his pants were sagging, he was pulling them up. That's at least a rational, alternative, reasonable explanation for that, which again is reasonable doubt. I want to talk a little bit about the videos that we've seen from Mr. Lewandowski that they offer to you, that they're submitting that shows Mr. Anderson running away minutes after the events that night, and that is somehow consciousness of guilt. Okay, so let's say those videos show Mr. Anderson running away. So what? That proves nothing. Because as we have heard from the other witness testimony, and we've seen from those videos, most of the other people ran away too after that happened. Yes, he would have taken off after those gunshots were fired. And again, I want to remind you, I told you in my opening statement that I think the testimony would bear out that Mr. Anderson was at that party at that night. I've never disputed that from the very beginning. I told you that in my opening statement, that I believe that the evidence would show that, and I believe that it has. But what it has not shown is that Mr. Anderson committed these crimes that he's being accused of. So Mr. Anderson runs away after shots are fired, like most everybody else did when that occurred. I mean, common sense would tell you that's what most people would do after that happened, isn't it? Again, that proves nothing. Some things to note about those videos: you don't see a mask on the person running away, do you? The detective admitted that, but I mean, she didn't need to. I mean, it's clear for anyone to see. You didn't see the person in those videos drop anything or discard anything. The detective and Mr. Lewandowski both stated the same. And again, the videos speak for themselves. You can clearly see that that is the case. And they're trying to argue to you again that it is somehow of an inculpatory nature that Mr. Anderson is coming back later that day, poking around the property and the windowsills. In broad daylight, mind you, where the neighbors or anybody else or anybody that would have been at home, could have seen him or made contact with him. What is the implication that they're exactly getting at there? They didn't come out and say, but is the implication that Mr. Anderson went back there to retrieve some type of evidence of his guilt? Perhaps he left the firearm behind there, either intentionally or unintentionally. But again, the videos don't show that person discarding anything or dropping anything. So let's see where that leads. So again, Mr. Anderson's there later on that day, again, in broad daylight for all the world to see, or Mr. Lewandowski or his wife or anybody who may be at home to have contact with him. What's he supposed to do if that happens? Oh, sorry to have bothered you, but I shot somebody last night, may have killed them, and I think I may have dropped the gun behind. It's very incriminating. I really need that. You didn't happen to come across that, did you? Now again, they didn't come out and say that, but when you vocalize that implication, that distresses how ridiculous that is and how preposterous that sounds. What's a more likely, plausible scenario? That maybe Mr. Anderson is there later on that day because when he's running away frightened after gunfire rings out, that he's there looking for some more of an innocuous item that he may have dropped. A cell phone, perhaps. Remember, there were cell phones around in that area that were recovered. We know that from the detective's testimony. Perhaps he thought that he dropped a wallet or a key or something like that. That is a more rational, plausible explanation for him being there, as opposed to him going back again in broad daylight for all the world to see, or to be discovered by the homeowner later that day to retrieve, I don't know, a firearm or whatever it was that they believed that he would have left behind, when we can clearly see nothing was left behind during those videos. It makes no sense. But they would have you believe that moments after that shooting occurred, for whatever reason, he just discarded his sweatshirt, threw that away, but apparently still kept the gun because I guess that he may have dropped it or purposely left it behind at Mr. Lewandowski's property and thought that he could go back there and retrieve it later that day. That makes no sense. That makes absolutely no sense at all. And the reason why it makes no sense at all is because it's not true. And the inferences they're asking you to draw from that are not reasonable. Why would someone run away from an event like that if they're not guilty of shooting someone or committing some other type of crime? You mean like most of the other people that ran away from the party that night? People run for a number of reasons. Because they're scared, because they don't like the police, because they don't like to be involved. There's any number of plausible, rational explanations other than guilt for that conduct. And I would ask you to find just that. And again, that is a reasonable doubt. They talked about, and there was evidence presented that Mr. Anderson had a video of what went on that night on his phone. Again, so what? What does that prove? Teenagers, young adults were at a party where someone was getting pummeled in a melee where shots ended up getting fired. I'm sure tons of people would be, and apparently did, share that video around. Not just with those that attended the party that night, but it would make sense for them to send it to various other people and make it around with that, whether they were at the party or not. I mean, that is just the culture of the society in which we live in today. People record things, people share things, people send things. So simply because Mr. Anderson had that video or videos on his phone, so what? That proves nothing. Very likely and reasonable that many, many other people did as well. People that were at the party, and I'm sure people that probably were not at the party. So again, that proves nothing. You certainly didn't see any text messages in that phone where Mr. Anderson was bragging about what happened, or that he was bragging about, shooting Mr. Washington. No evidence of that. As I told you in my opening statement, you would not see any evidence of that, either in text message or social media, where he was bragging about shooting Mr. Washington or otherwise admitting to it. It's because no such evidence exists. If there was, you would have seen it. No evidence or testimony that Mr. Anderson admitted to or was bragging about pistol whipping Mr. Jackson that night. Again, just as I told you in my opening statement. And again, reasonable doubt comes not just from the evidence, but from the lack of evidence. And the people have discussed a little bit about the aiding and abetting instruction, and I'm not really going to belabor that. I think I've made my position very clear. I don't believe that Mr. Anderson shot anybody that night, and I don't think there's any credible evidence to suggest that he did. But also, when you were evaluating that particular instruction, let's say, okay, maybe he didn't, but maybe he was assisting the person that did in some way. And I argue to you that there is no credible evidence of that he did any such thing. Because you would have to be convinced that before or during those events that Mr. Anderson did something to assist in the commission of that crime. That he intended the commission of that crime that's been alleged, or must have known that the other person intended its commission of that crime alleged. It was a natural and probable consequence of the commission of that crime intended. I don't believe there is any credible evidence to suggest that is the case. Even if you believe that this big fray came about and that Mr. Anderson jumped in and did something in some way, that still does not get them there. Because there's no evidence that he intended to help or assist and anyone else in committing that crime against Mr. Washington by shooting him, if you do in fact believe that someone else actually shot Mr. Washington, but that Mr. Anderson was still involved in some way. And you will be instructed as it relates to the assault with intent to murder charge involving Mr. Washington, that you will be able to consider a lesser included offense of what we call assault with intent to commit great bodily harm, but less than a crime of murder. So let's say you're back there in the jury room deliberating and you believe that Mr. Anderson is responsible for shooting Mr. Washington. Or you're convinced beyond a reasonable doubt that he did. Now, I'm not conceding that for a nanosecond, but let's say you're back there and that is what you believe. I would urge you very strongly to consider, if that is the case, the lesser included offense of assault with intent to commit great bodily harm, but less than the crime of murder, because intent is an extremely important element. There's a lot of facts to consider when trying to determine what the intent of the shooter would have been. Keep in mind, now I know the people have been very meticulous in talking about intent and why they believe the intent would have been to kill Mr. Washington. And they've talked about some of the medical testimony and some of the complications that Mr. Washington endured, or some of the things that could have happened to him had things not going, completely right with his medical care and the timing of it. And thankfully, Mr. Washington did live through this. But keep in mind, simply because the medical consequences of him being shot, even if they could have been lethal, that does not mean that that was the intent of the person who shot him. A lot of facts to consider. The shooter was at very close range, yes, but I think that undercuts in a large way the people's theory that it was the shooter's intent to kill Mr. Washington. Because if he was at that close of range, which they are stressing to you, and that goes along with their belief that the shooter had the intent to kill Mr. Washington, the shooter was at close range and could have easily shot Mr. Washington in a more fatal or vital area, such as the chest or the sternum or the head, if in fact that's what that person wanted to do or intended to do. I think the fact that he was shot in the lower part of his body and the legs would indicate otherwise. Also, there was no testimony that prior to the shooting, the shooter was shouting things like, "I'm going to kill you or you're dead," or things of that nature that could provide strong circumstantial evidence of the shooter's intent. Nothing along those lines. I think the evidence of circumstantial evidence would strongly suggest that if in fact you do believe Mr. Anderson shot Mr. Washington, or whoever shot him, that person was intending to injure or inflict great bodily harm upon him, but not to kill him. Because I think he very could have easily done so if that was in fact that person's intentions. However, you only get to that part of the discussion if you are convinced beyond a reasonable doubt that Mr. Anderson did in fact shoot Mr. Washington, which I have argued to you and I firmly believe that they have not. And if you do believe that, then you vote not guilty on that count and you continue on with your deliberations on the other charges. What really happened here? I don't know. And I don't think we'll ever know for certain. There are some things that are simply not in dispute. We're not disputing again that Mr. Anderson was at the party that night. However, there are a lot of things that are in dispute and a lot of things that we simply don't know or can be certain of. And it's not your job, because we're not here to put together pieces of a puzzle or to solve a mystery. We're not even here to determine if Mr. Anderson actually did what he's been accused of doing. I know that may sound surprising to some of you, and you may be thinking, well, what have we been here for over a week for? You're here for one reason and one reason only, to determine if the people have met their burden of proof. If they have met their burden of proof by proving Mr. Anderson's guilt to you beyond a reasonable doubt. And they clearly have not. Haven't even come close. And you should have no problem at all rendering a verdict of not guilty. Should be one of the easiest decisions you've ever had to make in your entire lives. And we've talked about the burden and the burden of proof beyond a reasonable doubt, and that it's not proof beyond all doubt or any doubt, and that's absolutely correct. It's not proof beyond even the most whimsical of doubts. However, don't let that fool you either, ladies and gentlemen. While it may not be proof beyond all doubt, proof beyond a reasonable doubt, that is still the highest standard and the highest burden of proof that we have in our legal system. And if there ever was a case where reasonable doubt existed, it is this case. If the facts and evidence in this case do not amount to reasonable doubt, then we should just abolish the doctrine as a shallow, hollow, and meaningless phrase. If this isn't a reasonable doubt case, then what is? Perhaps the doctrine of reasonable doubt could be best illustrated in this way. If your state of mind as a juror when you're back there deliberating this matter, you know, I kind of believe that he's guilty. If I were forced to bet on it, I'd say he's guilty. I think he's probably guilty. That is not enough. You cannot render a verdict of guilty unless you are convinced, unless you are believed, unless you believe beyond a reasonable doubt that he is guilty. And can anyone honestly say that there is not at least one single reasonable doubt about just one of the elements in this case? Just one. Because keep in mind, they just don't have to prove some of them to you. They don't have to prove most of them to you. They have to prove all of them. Each and every one. Just like we talked about in voir dire. Ingredients in a recipe. They need to prove all of those elements to you beyond a reasonable doubt. In summary, when you're back there deliberating in that room, consider that there are three separate independent grounds that would justify a verdict of not guilty in this case. First, the decided weight of the evidence points to Mr. Anderson's innocence. Second, if there are two reasonable conclusions that can be reached from the evidence, one of guilt and one of innocence, you should adopt a conclusion of innocence. Certainly at an absolute minimum, at least one reasonable conclusion from the evidence is that Mr. Anderson is not guilty for the various reasons that I've stated. And finally, we return, as we must always do, to the doctrine of reasonable doubt. Again, the people have undeniably failed to meet their burden in this case. They have in no way proven Mr. Anderson's guilt beyond a reasonable doubt. And I've done my best to, I think, address all of the issues as it relates to the evidence, the elements, and the instructions in this case from our perspective, as well as trying to anticipate some arguments so that I can address those up front that the people may raise on rebuttal, because this is the last opportunity that I will have to speak with you. The people will have an opportunity to get up here and speak with you and attempt to rebut the arguments that I have made. I will not have the opportunity to do that. So I must both make my argument and try to preempt what I believe the rebuttal responses will be to some of mine. This is the last opportunity and the only opportunity that I get to speak with you after all the facts and evidence in this case has been presented. There is only one verdict, ladies and gentlemen, that is compatible not only with the evidence in this case, but with justice. The facts, the evidence, and the law in this case cry out for justice. justice being served by your returning to this courtroom with a verdict of not guilty. Not guilty. And on behalf of Mr. Anderson, I want to thank you also very much for the time and the attention that you have given to this matter to honor your civic duty. I know this has been a very lengthy trial for all of you. It's spilled over into the third calendar week. I want you to know that that is not a sacrifice that has gone unnoticed. It is certainly not unappreciated. You are 12 very reasonable men and women. That is why you were selected. Martez Anthony Anderson stands accused. He has been let down and disappointed by absolutely everyone involved in this case. From the police department who investigated it, to the prosecutor's office who reviewed it. His faith has not been misplaced in you. And I have all confidence in the world that you will not let him down. Thanks so much, ladies and gentlemen.
Thank you, counsel. On behalf of the people, final word.
One moment, please, Your Honor. Thank you.
People run for all kinds of reasons, but they hide for one reason: they committed a crime. Okay, this defendant was not told to run that night. He was told to hide. He was told to hide, ladies and gentlemen, because just moments before he had pulled the trigger on Miles Washington inside that parking lot. And the claim that the next day he went over there as just a stroll on an afternoon in the sun on a summer day with a full hooded sweatshirt on, going back to a residence he has no connection to, and starts fishing around at that residence because he's looking for a key, or he's looking for his cell phone, or he's looking for something innocent. Well, guess what? None of that is supported by what? Any evidence that you heard in this case. And that's interesting, ladies and gentlemen, because you know what? Nothing that counsel just said to you is supported by any evidence in the case. This is counsel's argument. Argument is not evidence, and he is giving you facts to consider that are not in evidence, ladies and gentlemen. A reasonable doubt is just that. A doubt is a fair and honest doubt growing out of the evidence or the lack of evidence in this case. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. What the defense is trying to give you is possible doubt. For example, the great identification conspiracy that existed between Martrell Jackson and Anaya Williams and Miles Washington. Well, when did that great conspiracy to misidentify this defendant who they don't know, who they have no connection with, who they have no problems with, who they have no beats with it, when did it start? Did it start the night that Martrell Jackson stayed on scene? When he, who the defense concedes was at the party, apparently ran, and we know where he ran to? And is it reasonable for people to run? Is it reasonable for people to run and then hop a fence and then hop another fence and then to go back to the house the next day? Okay. But the great identification conspiracy, was it Martrell Jackson who did this, who stayed on scene to help his friend, who spoke to the police, who gave his initial identification to the police of the shooter, black male, slim build?
Who gave the description?
Gave his initial description to police, black male, slim build, okay? Black shirt with white graphics on it and black pants, the definition, the description that exactly met the description that he made in this place. We made that description right after the shooting. Is that when the great identification conspiracy started? And so don't bite on it for a second when the defense says, I'm not alleging any malevolent intent or conspiracy between these. That's exactly what he's talking about. He's saying that these three witnesses somehow conspired with intent to come in here and frame this individual, ladies and gentlemen. When you have people who frame, they come in with lock solid stories. They sit there and they vigorously point to that person. He said, I'm going to kill you. And he pointed his gun sideways. And he did this, and they are in lockstep, and they are in absolute script. They don't go up and testify like that, ladies and gentlemen. What we have either are people who are honestly telling you the truth of what they observed that night, or you have the worst colluders in the entire world. This whole idea that maybe Miles is coming in and feels guilty for the fact that he made an initial identification and he doesn't want to come in and say he made the wrong identification. Maybe that's what's going on. Is that in evidence? Did that come out on cross-examination? Did any of that come out in examination? Well, maybe Anaya is trying to back him up and now she feels bad because she doesn't want to go back on what she said. Does that make sense? Is that in evidence? Is that an actual fact in this case, or is that something that the defendant is making up? Because none of the argument that you just heard, ladies and gentlemen, is based on the facts and evidence in this case. Let's talk, ladies and gentlemen, about the defense of he didn't do it, but if he did, there's no assault with intent to murder, because that's the defense. You see, the defense is he was there, but he didn't do it. But he ran, but if he was there and he did do it, he didn't intend to commit murder. That's the defense. And you have us weave through trying to tie that defense together with facts that are not in evidence. Go back and examine what counsel just said and look at how much of that is actually in evidence, how much of that came out, and how much of that is just argument trying to do what? Explain away the evidence. In order for you to believe what counsel just said, you have to ignore all of the facts of this case. You have to ignore it. And you have to rely on his version of events, none of which is in evidence. And that, ladies and gentlemen, that's a possible doubt. That is not a reasonable doubt. That is not in accordance with the standard that the court gives you. The standard that counsel read to you, would you bet on this and all that things? That's not the law. In fact, we've adhered on this. So we asked each and every one of you, if you heard a different standard for beyond a reasonable doubt, whose standard would you follow? You follow Judge Aquilina's description, and a reasonable doubt is just that. It is a reasonable doubt based upon reason and common sense after careful consideration of the evidence in this case. Look at all the evidence. Don't listen to me, folks. All right. My job is to present evidence to you and argue those facts to you. So what we encourage you to do is go back and look at all the exhibits, look at the videos, look at the testimony, look at it in the context of the independent instructions for credibility and identification. Look at what counsel said and see if any of that is supported, because it simply is not. These theories about why people are making things up, and these theories about why people are running, and these theories about why people are going back to houses, all these things, none of it's in evidence. Look at the actual evidence, apply it to the standards, take it all apart, watch the video 50 times, deliberate that, and then come back to reason and common sense. Because when you come back to reason and common sense, there's only one conclusion. You got people in here who came in without motive, without bias, without any reason, made identifications in this case, identifications that meet the totality of the evidence in this case. And do not for 1 second accept that the Lansing Police Department did not do their job in this case. You know the world that this happened in that night. Look, ladies and gentlemen, it's okay for defense counsel to get up there and say, everybody runs. My gosh, my client was just one of the runners. But why wouldn't the police be able to get all the video footage of what's going on? That's just a way to spin up and try to twist up all the evidence in a way that reaches a possible doubt, but not a reasonable doubt. For defense counsel to get up here and say it's an easy decision, there's never been more reasonable doubt in any case, is absolute nonsense. It is not based on the evidence. You must look at the evidence presented, apply it to the law as read to you by Judge Aquilina, and in that way decide this case. Take it all back there, deliberate on all. Don't listen to what I say, but come back to reason and common sense. And when you do, ladies and gentlemen, we will ask you, in common sense, in reason, to hold this defendant accountable, as we have stated, accountable for those that are guilty of assault and attempted murder, felony firearm, and the additional charges. Thank you.
Thank you. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job, no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove his innocence or to do anything at all. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or a lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide a case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that defendant is charged with crimes and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and everyday experience. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these things only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe I have an opinion about the case, you must pay no attention to that. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding this case. Make your decision only in the evidence I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or any part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, religion, race, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There are no fixed set rules for judging whether you believe a witness, but it may help you to think about some of these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not important, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that's important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about other things, you may simply accept the part you think is true and ignore the rest. Count 1, assault with intent to murder, as to Miles, Washington. Defendant is charged with the crime of assault with intent to murder. To prove this charge, a prosecutor must prove each of the following elements beyond a reasonable doubt. First, defendant tried to physically injure another person. Second, when defendant committed the assault, he had the ability to cause an injury, or at least believed he had the ability. Third, defendant intended to kill the person he assaulted, Miles, Washington, and the circumstances did not legally excuse or reduce the crime. Defendant can only be guilty of the crime of assault with intent to commit murder if he would have been guilty of murder had the person he assaulted actually died. If the assault took place under circumstances that would have reduced the charge to manslaughter, if the person had died, defendant is not guilty of assault with intent to commit murder. Voluntary manslaughter is different from murder in that for manslaughter, the following things must be true. First, when defendant acted, his thinking must have been disturbed by emotional excitement to the point that an ordinary person might have acted on impulse without thinking twice from passion instead of judgment. This emotional excitement must have been caused by something that would cause an ordinary person to act rashly or on impulse. The law does not say what things are enough to do this. That is for you to decide. Second, the killing itself must have resulted from this emotional excitement. Defendant must have acted before a reasonable time had passed to calm down and before reason took over again. The law does not say how much time is needed. That is for you to decide. The test is whether a reasonable time passed under the circumstances of this case. If you find the crime would have been manslaughter had the person died, then you must find defendant not guilty of assault with intent to murder and decide whether he is guilty of any lesser offense. Assault with intent to do great bodily harm less than murder as to Miles, Washington. You may also consider the lesser charge of assault with intent to do great bodily harm less than murder. To prove this charge, the prosecutor must prove each of the following beyond a reasonable doubt. First, defendant tried to physically injure another person. Second, at the time of the assault, defendant had the ability to cause an injury, or at least believed that he had the ability. Third, defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. Count 2, weapons carrying concealed. Defendant is charged with the crime of carrying a concealed pistol. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, defendant knowingly carried a pistol. It does not matter why defendant was carrying the pistol, but to be guilty of this crime, defendant must have known that he was carrying a pistol. Second, this pistol was concealed on or about the person of the defendant. Complete invisibility is not required. A pistol is concealed if it cannot easily be seen by those who come in ordinary contact with the defendant. Defendant is also charged in count 3 with felony firearm. This is a separate crime of possessing a firearm at the time he committed or attempted to commit the crime of assault with intent to murder or assault with intent to do great bodily harm less than murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, defendant committed or attempted to commit the crimes of assault with intent to do great bodily harm or assault with intent to murder, which have been defined for you. It is not necessary, however, that defendant be convicted of that crime. Second, at the time defendant committed that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the gun was loaded. A pistol is a firearm. Count 4, assault with a dangerous weapon. As to Martrell Jackson, defendant is charged with the crime of assault with a dangerous weapon. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, defendant either attempted to commit a battery on Martrell Jackson or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with that person. Second, defendant intended either to injure Martrell Jackson or to make Martrell Jackson reasonably fear an immediate battery. Third, at the time defendant had the ability to commit battery, appeared to have the ability, or thought he had the ability. Fourth, defendant committed the assault with a dangerous weapon. A dangerous weapon is any object that is used in a way that is likely to cause serious physical injury or death. Some objects, such as guns or bombs, are dangerous because they are specifically designed to be dangerous. Other objects are designed for peaceful purposes, but may be used as dangerous weapons. The way an object is used or intended to be used in an assault determines whether or not it is a dangerous weapon. If defendant threatened to use an object or uses an object in a way that was likely to cause serious physical injury or death, it was a dangerous weapon. You must decide from all facts and circumstances whether the prosecutor has proven that the pistol in question here was a dangerous weapon. Count 5, felony firearm. Possession of firearm at the time of commission or attempted commission of felony. Defendant is charged in count 5 with a separate crime of possessing a firearm at the time he committed or attempted to commit the crime of assault with a dangerous weapon. To prove this charge, prosecutor must prove each of the following elements beyond a reasonable doubt. First, defendant committed or attempted to commit the crime of assault with a dangerous weapon, which has been defined for you. It is not necessary, however, that defendant be convicted of that crime. Second, at the time defendant committed that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the gun was loaded. A pistol is a firearm. If defendant intended to assault one person, but by mistake or accident assaulted another person, the crime is the same as if the first person had actually been assaulted. The intent with which an assault is made can sometimes be determined by whether a dangerous weapon was used. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. One of the issues in this case is identification of defendant as the person who committed the crime. The prosecutor must prove beyond a reasonable doubt that the crime was committed and that defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. Also, think about the circumstances at the time of the identification, such as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. You may also consider any times that the witness failed to identify the defendant or made an identification or gave a description that did not agree with this identification of defendant during trial. You should also examine the witness's identification testimony carefully. You may consider whether the evidence supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict defendants as long as you believe the testimony and you find that it proves beyond a reasonable doubt that the defendant was the person who committed the crime. Defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. In this case, defendant is charged with committing assault with intent to murder or assault with intent to do great bodily harm less than murder or intentionally assisting someone else in committing it. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abettor. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the alleged crime was actually committed, either by a defendant or someone else. It does not matter whether anyone else has been convicted of the crime. Second, before or during the crime, defendant did something to assist in the commission of the crime. Third, at that time, defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable cause or consequence of the commission of the crime intended. It does not matter how much help, advice, or encouragement defendant gave. However, you must decide whether defendant intended to help another commit the crime and whether his help, advice, or encouragement actually did help, advise, or encourage the crime. Even if defendant knew the alleged crime was planned or was being committed, the mere fact that he was present when it was committed is not enough to prove that he assisted in committing it. You may consider whether defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that defendant had a reason to commit the alleged crime. He only has to show that defendant actually committed the crime and that he meant to do so. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. There has been some evidence that defendant ran away or hid after the alleged crime. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of the consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that defendant had a guilty state of mind. You have heard evidence that before the trial, a witness made statements that may be inconsistent with his testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. You've also heard evidence of a prior recorded recollection from Miles Washington. You may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statements when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness, Dr. Nicole Fraticelli, who has given you her opinion as an expert in the field of orthopedic trauma surgery. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts she gave for her opinion and whether those facts are true. You should also think about the expert's qualifications and whether her opinion makes sense when you think about all the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Possible penalties should not influence your decision. If you find defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to Brian. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. And that would include the videos. We do have a computer that will send back, but that's a clean computer, so you can play them at your leisure. When you go to the jury room, you'll be given a written copy of the instructions that I'm now reading. As you discuss the case, you should think about all my instructions together as a lawyer to follow. Defendant is charged with 5 counts. That is, the crimes of count 1, assault with intent to murder, or the lesser crime of assault with intent to do great bodily harm less than murder. Count 2, carrying a concealed weapon. Count 3, felony firearm. Count 4, assault with a dangerous weapon. And count 5, felony firearm. These are separate crimes, and the prosecutor is charging that defendant committed all of them. You must consider each crime separately in light of the evidence in the case. You may find defendant guilty of all, or any one, or any combination of these crimes, or not guilty. When you go to the jury room, you should first select a foreperson. You can see, and you know, originally we had a jury of 14, and we told you we would bring it down to 12, and we had 2 individuals who had things come up. So you are it, you are the 12. You will first choose a foreperson. A decision in a criminal case must be unanimous. And you must only talk about the case when you are all present in the jury room. So if someone is in the restroom, then you have to cease talking until all 12 of you are again at the table. You should talk amongst yourselves, go through each count, the evidence separately, give each person a chance to weigh in on their opinion, discuss everything out. You can hold your opinion, whatever it may be, or you may change your opinion as you discuss the issues with the other jurors. So if you decide to change your mind, that's perfectly fine. But you don't have to change your mind if you disagree with the other jurors. But everybody needs a fair chance to talk it out and to be heard. You will each receive a copy of the instructions I read, but I only send back 1 verdict form. It is the responsibility of the foreperson to fill out the verdict form. You'll all have access to it, it's not a secret, but I don't send back 12 so that we get confused on the original or whatever. It's just easier for us to know that this becomes part of the official record. So I do need the foreperson to fill it out as each of you decide on your verdict for each count. And then the foreperson will date and sign it. It reads as follows. Count 1, assault with intent to murder, as in Miles, Washington. You may only return 1 verdict on this charge. Mark only 1 verdict on this sheet. There's a line, not guilty. There's a line, guilty of assault with intent to murder. And then under that, there's a 3rd line, guilty of the lesser offense of assault to do great bodily harm less than murder. Count two, carrying a concealed weapon. You may return only one verdict on this charge. Not guilty, guilty of weapons carrying concealed. Count three, felony firearms. You may return only one verdict on this charge. Mark only one verdict on this sheet. Not guilty, guilty of felony firearm. Count four, assault with a dangerous weapon, S. Martrell Jackson. You may return only one verdict on this charge. Mark only one verdict on this sheet. Not guilty, guilty of assault with a dangerous weapon. Count five, felony firearm. You may return only one verdict on this charge. Mark only one verdict on this sheet. Not guilty, guilty of felony firearm. Then there's the dates line in the line jury person's signature. Counsel, can you approach a moment? All right, on behalf of the people you said, so the reading of the set of instructions.
Thank you. We just had a conference at sidebar and one instruction the court orally read. We think the court covered it adequately. I know it'll be in the final written instructions. Other than that, we have no objection.
I would agree with you, with that, Your Honor. There appears to be one instruction that was omitted, but I think the court, recited it from, memory quite well. So other than that, I have no objections to the reading of the instructions.
All right, thank you. The other, I mentioned this to you when you were selected, but when you come back and you've read your verdict, either counsel can ask to hold a jury, and if they do, then I would individually ask you, was the verdict that the foreperson read your verdict, and was it the verdict of the whole jury? And each of you would individually ask those two questions. Please raise your hand and state your name for the record.
Brian Ray.
Do you solemnly swear or affirm that you will, to the utmost of your ability, keep the persons sworn in as jurors on this trial from separating from each other? That you will not allow any communication to be made to them orally or otherwise? That you will not communicate with them orally or otherwise except upon order of this court, or to ask them if they have agreed upon a verdict until they are discharged? That you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I do.
Let me just add on, you will not have your phones, iPads, computers, any electronics that you brought. There is a phone there. If you have any questions, All right, we are back on the record at,
The red is what I got it.
okay, 2:42. They asked for a description of the gunman given at the time of the shooting, and I just gave the answer. The evidence is closed. Use your notes and collective memories. We're not adding to that, their evidence. So I think the answer is going to be in what they next asked for. Can we view the court report of Martell Jackson's testimony? Can we see the testimony of Miles Washington? Can we see Eddie Williams' testimony? So Nancy went through and she can tell you they run anywhere, and we have to get the other court reporter. So they run anywhere from 45 minutes to about 2 hours. So I don't know if they're going to probably won't work until about 3:30, but that's where we are. They're waiting to read back for the readbacks. They gave us all 4 of those at the same time.
We approach this.
Oh, wait. Me with witness. All he wants to see is. Yeah, that is. It was given. It's in all the.
Yeah. Right, and so.
You gonna bring it in? So you're back
Yeah.
tomorrow, basically?
Get it together and then.
Start to stop. Can't reach out to it. At 3:30. Brian, you can tell me now.
tomorrow at 9 or 3:30.
Okay.
If they know what testimony they want right back to, can you ask them?
Yep.
So I can have that ready.
They want,
Go back on the record.
Yeah, the three witnesses they listed.
yeah,
That's all for the record, just today.
Kelly said that she could do here tomorrow, or she could even do it by Zoom if you were okay with her doing it by Zoom. If they still want hers.
Zoom, she has to go in the jury, though.
Well, I mean, we could take a computer in there and Zoom, but it was up to you, so.
That doesn't matter to me.
Yeah, just see what they want right back first. If
Okay.
they want it all, they can have it all.
All right, we'll go do that.
Or she can give it.
Best
All
practice.
right,
Wait, are we going back on the record?
I guess so.
Okay, but you gotta give me a minute.
I'm
Because
sorry, Judge.
I closed out this.
Just been talking about so many things, I just feel weird.
Come on, turn it.